All right, we're back. Welcome back, everyone, to the Select Committee on Blockchain and probably emerging technology in the near future. Before lunch, that we were considering 25 LSO 71, working draft 0.4, and had some discussion on the bill. We can have a little more discussion on what direction we want to go with the bill, and then Mr. Co-Chairman, I think we'll just forward it on without objection to the next Select Committee for any final consideration. But at this point, committee, what are everyone's thoughts with regard to any potential changes we would want to see for the next draft? I think we need to resolve what we're going to do with Title 13 and that discussion, and then any other ideas that we have. Mr. Co-Chairman?
Thank you, Mr. Co-Chairman. I guess is Representative Yen, is he still
We have him back. Good.
back on? This was kind of his brainchild. So, Mr. Minority Floor Leader, was there anything else you wanted to add on this before we?
Mr.
on the
Chairman,
next
I think
meeting?
the only other thing noted was technologies, plural. I think that would make sense for the next bill draft.
Great. So make sure we get that, and then we'll talk about Chapter 13. One other consideration, does anyone else have anything they want to add before I raise a couple concepts? I don't see any right now. On the bottom of page 2, we do eliminate, through the amendment, blockchain, financial technology, and digital innovation in Wyoming, et cetera, unless the legislation relates to Title 13. One possible change to contemplate is to keep that language as an A paragraph, and then to make the A, B, and C paragraphs B, C, and D, for the same reason that we're keeping blockchain, so that there's some continuity. It's obviously kind of redundant to some degree and included in what we have in existing A, B, and C. But again, for the same reasons we're keeping blockchain, I don't think there's a downside to it, but it provides a little continuity on that. I don't know if anyone has any thoughts.
So, Mr. Co-Chair,
Yeah.
if I understand your idea correctly, it's keeping most of that stricken language and putting it down as subsection A, and then just renumbering accordingly. Am I understanding that correctly?
Yeah, exactly.
Okay.
And then we obviously have, in which case unless the legislation relates to Title 13 of the Wyoming statute, in which case, and then we could, one way or another, include language similar to Romanet 3 to figure out how we want to handle Title 13. So that provides a little bit of continuity on that. Does anyone have any objection to getting the next draft to include that language? Is that reasonable? Representative Yin, does that make sense? And we can still talk about what we do with Title 13 as well as a
Yeah,
separate
Mr.
issue.
Chairman,
Representative Yin?
I think that's likely fine. Maybe I'm a little confused on what the intent is there, but as long as we resolve the Title 13 issue at some point, I think it doesn't bother me where that language goes.
Okay. Well, yeah, and again, it's just with the committee being presumably blockchain and emerging technologies, putting in a new A paragraph that was blockchain, financial technology, and digital innovation in Wyoming, and then again, unless the legislation, we'll figure out what we do there, connects to the blockchain side of things, and then the A, B, and C in the draft would basically be emerging technologies language. So I think it provides continuity from what the select committee has done and is doing now to what it would be doing in the future. And then at some future date, theoretically, if somebody wanted to, they could eliminate that first paragraph once you no longer need that continuity. That's kind of the concept there, so that it's not all new. All right, any concerns with that? Without objection, let's incorporate that change. And now let's talk about Title 13 and how we want to handle that. So we did get feedback, and we reached out to the co-chairman of the Minerals Committee that are there right now. And they had concern with eliminating the Minerals Committee from the process. So, Mr. Co-Chairman, I think the question is how we would want to draft that so that we keep the Minerals Committee in the process, but provide a little more flexibility. Where what really led to this was what we ran into last session, where we didn't have the flexibility to simply sponsor something, even if the Minerals Committee would allow us to. right? We couldn't sponsor something within Title 13. The Minerals Committee didn't have a problem with us sponsoring it. And so at a minimum, it seems like just coming up with language that would allow us that opportunity, afford us the opportunity to sponsor something with the approval of the Minerals Committee or with the consent of the Minerals Committee seems like at a minimum what we need to be able to function. So and that's not quite what Romanet 3 does, that language. It's close. So it requires its chairman to consult with the chairman of the Joint Minerals Committee prior to sponsorship. It could say, we could change the Romanet 3 language to require its chairman to receive approval, basically, from the chairman of the Joint Minerals Committee. I don't see why anyone would object to that. That means that we have to ask the co-chairman. If the co-chairman of the Minerals Committee say it's okay, then we can sponsor it. If they say no, then we can't sponsor it. That probably is consistent with our interests and the interests of the,
Which I think
the
advising consent is what they say in the bid.
it's
isn't it?
pretty much advise and consent. Although there's perhaps some debate and drama around that phrase. So I don't know whether we want to use advise and consent or just go with approve. Is everyone okay with that concept if we ask Mr. Hopkinson to incorporate that? And it doesn't have to be that specific language, but basically change it from consult with to receive consent or advice and consent or whatever from the chairman. Mr. Hopkinson, thoughts?
Mr. Chairman, my only thought on that is if we just made that kind of a simple change, then I don't think it's clear what happens if we don't get consent. Can we still send it to them to sponsor? I don't think that's clear. Do we want language in there that says if they don't consent, well, we can still send it to the committee for the committee's consideration? What are your thoughts on that?
That's a good question. My inclination would be the Minerals Committee would be able to, you would want to maintain the opportunity for the Minerals Committee to sponsor it. What we're asking for the chairman to do is allow us to sponsor it. So that would be the only thing they would let us out of the Title 13 requirement is kind of the intent as I understand it. So we have a requirement that since it's Title 13, it has to go to the Joint Minerals Committee. And then it would basically be unless allowed by the chairman that we could sponsor it. So if the chairman of the Minerals Committee say, you guys go ahead, then we can sponsor it. If they don't say that, then it would still be the existing current process, which would mean it would go through the Minerals Committee or we would individually sponsor it. Does that make sense, Mr. Hopkinson? Okay. I want to reach out to Representative Yin to see his thoughts on that, and then anyone else in the committee if they have any concerns.
Mr. Chairman, I think that is fine. I probably would not fully be in favor of it come the session, but I'm not opposed to having it in the bill draft now. Again, I don't think it's necessary to hamstring the committee with minerals, but I understand the concern that comes from the minerals chairman, given no one wants to give up power technically that they already have. So
Right.
have it in the bill draft as stated by you.
Okay. Then let's have it drafted that way for next time's consideration, and maybe and we can run it by the Minerals Committee chairs and see if that satisfies them. Mr. Hopkinson?
Mr. Chairman, happy to draft it that way. I did want to just briefly update the committee. I looked over the lunch hour at the other select committees because there were some questions. The only other committee that has to run their bills by a standing committee is select tribal. But the other select committees generally are a little more restricted in their sponsorship ability. It tends to be quite a bit more narrow than what this committee has. I didn't see any indication that any other select committee has ever sponsored a bill to expand kind of their sponsorship authority. So from what I could tell, that has not happened before.
Okay. Thank you, Mr. Hopkinson. Further questions or discussion on this? All right. So without objection, let's carry this bill over to the next select committee meeting and make the changes of changing emerging technology to emerging technologies. Make the change of reinstating a paragraph A, which would include blockchain, financial technology, and digital innovation in Wyoming unless the legislation relates to Title 13, and then have flexibility for David to change that language so that we have the ability to get permission to be exempted from that provision by the chairman. All right. So we'll see that one next time. And with that, we are back to the agenda, Mr. Co-Chairman, and
Generally on time.
mostly on time. We're very close. We are to our 1:30 artificial intelligence governance discussion, where the first thing that we'll be hearing about is a review of other states' misleading synthetic media and deepfake legislation. And let's have Emily, who we've missed, come up. And thank you very much, Emily, for working on this. And please, the floor is yours to walk us through this memo.
Thank you, Mr. Chairman. Glad to be back. For the record, my name is Emily Wongan. I'm the Legal Division Intern at the Legislative Service Office. For the topic of artificial intelligence governance, I have a memo for you, Material 701. And so this memo is an overview of state laws relating to deep fakes and synthetic media. So generally, state laws have created civil and criminal penalties in one of two contexts, either around elections or explicit material. And the definitions used in these statutes vary from jurisdiction, and you can find those in Appendix A at the end of the memo. So on the first section regarding elections, for criminal penalties, Minnesota and Texas create criminal penalties for disseminating deepfakes to spread election disinformation or in order to injure a candidate. There are different time periods for which this law would apply. In Minnesota, it's 90 days before an election, whereas in Texas, it is 30 days. And these states have different maximum penalties. In Minnesota, it's generally up to 90 days imprisonment and or a $1,000 fine. And there are enhanced penalties detailed on page 2 of the memo. And in Texas, it's up to 1 year in prison and or a $4,000 fine. For civil penalties, a lot of these statutes overlap within these categories that I've set out. I just kind of organized them by their most prominent feature. So we have statutes regarding the disclosure of whether or not something uses a deep fake or a synthetic media, and then others focus on when the communication is disseminated, and then others create a private right of action for violations of those laws. Utah and Oregon require specified entities to make disclosures when they use deepfakes in their communications. Utah's law is applicable to candidate committees, PACs, political issue committees, political parties, and people using campaign contributions. They also require disclosure in the metadata that it's using artificial or synthetic media or deepfakes. It also permits the subject of the deepfake to bring a civil action against the person who disseminated the deepfake. Oregon's law doesn't limit it to specific entities or doesn't specify that it's limited to specific entities and is enforced by the Secretary of State, who can impose up to a $1,000 civil penalty. Now, Arizona and Colorado focus on when a deepfake is disseminated in relation to when an election is. Colorado's law prohibits disseminating deepfake communications regarding a candidate for that office 60 days before a primary election and 90 days before a general election. Generally, those time kind of overlap between a primary and a general election. And the violation of this law is enforced by the Secretary of State's office, and a hearing officer within the office will impose a penalty of at least $100 or 10% of the amount spent to distribute the communication. But the hearing officer can increase the penalty depending on the level of public exposure the communication receives. So if something goes viral on Twitter, they might be subject to a higher penalty for that versus something that maybe a few people saw. In Arizona, they have a digital impersonation law, And this one does not distinguish between a primary and general election and just has a 90-day limit. Violations of this law result in a $10 fine for each day the content is distributed without disclosure that it's a deep fake, and is paid to either the Secretary of State or the county clerk, depending on which office the candidate is seeking. Finally, Arizona and Idaho create a private right of action for candidates who are depicted in deep fakes without their consent. Arizona's law, which is different from the one I previously mentioned, provides for declaratory relief if it is requested within 180 days of an election. And Idaho's Fair Elections Act, I believe it stands for Freedom from AI Rigged Elections, permits a candidate to seek equitable relief and damages from a person who disseminates a deep fake of them. Before I continue, does anyone have any questions regarding elections and deep fakes?
Yeah, let's take a minute to see if we have any questions. So I have a few, starting with the most recent one with the FAIR Act. So bring an action for equitable relief and damages if there's deceptively represented through synthetic media in an electioneering communication. Who can bring that action? Is it only in that instance the candidate that can bring the action, or can somebody that was deceived bring an action?
Are you talking about the fair elections?
Yeah, for the
Yeah.
fair one right there.
I think it would just be the candidate, but I can look into that more. I'm not sure if there's been any case law about this act, since it is fairly new. But I think it would be just the candidate, as they're the one who was injured by the deepfake.
And so this is, some of the conversations we've had relate to how you can actually create one of these acts that kind of is resistant to loophole attacks, where a lot of them provide workarounds. And I see some dates I was going to ask about. I'll get to those in a second, how that works. But it seems that, for example, a manipulation of candidate A's actions might be illegal under the FAIR Act, but what if I created a false constituent and deep faked that false constituent into saying bad things about one of the candidates, or alternatively good things about the other candidate? Would you see where that would fall under the FAIR Act as being a violation?
I'm not sure. I think it's pretty specific to the candidate and misrepresenting the candidate in a deep fake. I don't believe it says much on whether or not, if a deep fake's used just with the general intent of injuring. I think it generally needs to have the candidate depicted.
Okay, and back to the other half of that question, if I make a deep fake of candidate B in a heroic circumstance where they seem to have done something incredible, save 5 people from a burning building, candidate A wouldn't have a private right of action to say, no, that's false under the FAIR Act either, right? Because I would have to be manipulating something about candidate A, as I understand it. Is that fair?
I think that's, how I understand it as well, because it wouldn't be the candidate having their speech deceptively represented.
Gotcha. On the timeline aspects, we've got a number of different timelines, and they're probably not all uniform, but it tends to be the idea of you can't violate this within 90 days or 180 days of the election, and there was a 30 days of the election. What would happen if I released the video 91 days before the election? I'm in the clear at this point in time. It's a deep fake attack of a candidate. And it spends the next 90 days on social media, but I don't take any further action as the creator of the deep fake. Do you see that either the criminal penalty statutes that we see from Minnesota and Texas, or even the civil penalty disclosures for Utah and Oregon, would govern those in any way?
Mr. Chairman, I'm not quite sure. These laws are pretty new, so there
Yeah.
hasn't been a whole lot of case law, about them. I think generally, if a person is disseminating the content, they might share it at some point within that 90-day period again. So at that point, it would be a clear violation, but if it's outside of those parameters, I'm not sure if them just disseminating it at that one point and then other people disseminating it. But if other people knowingly disseminating it with the knowledge that it did include a deep fake, they would then be liable under these laws.
Yeah, that was going to be my next question is how does, and that's the standard, knowingly disseminating. So a third party that is perpetuating it would also be disseminating. What about a platform? Are there platform carve-outs for all of these where Facebook and Instagram and other social media platforms would be exempt from it?
So generally, all of these laws actually have several exceptions, and one of them would include immunity for interactive computer services, information services, or other telecommunications providers. And that's in conformance with federal communications law, to give them that immunity from liability.
Okay. Thanks. Any other questions for Emily? Go ahead, Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. Emily, I know it looks like a lot of these laws have been passed within the last year or 2 years, pretty recently. In your review, were you able to come across any pending lawsuits that have been filed challenging this? And if so, what were the nature of those lawsuits?
I have.
Emily, go ahead.
Sorry, Mr. Chairman.
No, go ahead.
I have not. I could quick look that up too and get back to you to see if there are any lawsuits regarding that. But from what I recall, there have not been.
Mr. Co-Chairman, follow.
No follow-up.
Co-Chairman, follow. Okay. Any additional questions at this time? All right. Emily, did you have more to present on through the memo in the appendices or? Are we good?
Yes, Mr. Chairman. There's another section on
Great.
explicit deepfakes.
Okay, gotcha. Please
Um,
continue.
Thank you. So 3 states have criminal statutes regarding deepfakes. And while each crime has specific elements that are detailed, starting on page 4 of the memo, they generally make it a crime to disseminate a deepfake depicting a person's intimate parts or a person engaging in a sexual act if the person did not consent to that deepfake. Each of these laws, except for one provision in Louisiana's law, does not criminalize the possession of these deepfakes, but rather the dissemination. So in Louisiana, it is a crime to knowingly create or possess material that depicts a minor's intimate parts or a minor engaged in sexual acts if the person knows that it is a deep fake depicting a minor. So that's the section in which it is a crime to possess or create that deep fake material. If a person distributes the material, the penalty is enhanced. And Idaho and Minnesota create enhanced penalties for reoffenders, creating these deepfakes of anyone. And Minnesota has a list of factors at the bottom of page 4 that would enhance the penalty to a felony. And so Arizona and Minnesota have civil penalties for distributing explicit deepfakes. Minnesota's law mirrors its criminal law, but provides for civil remedies rather than criminal penalties. A plaintiff could be awarded an amount equal to the profit made from the dissemination, if there was any profit made, and a civil penalty of up to $100,000. And as part of Arizona's digital impersonation law that I briefly discussed when talking about elections deepfakes, a plaintiff could receive declaratory relief or injunctive relief and damages if the impersonation was published with actual knowledge that it was a deepfake. And then before I move on to exceptions, are there any questions?
Committee questions? We've had some conversations about the knowingly side of things and how that would be proven, and this is based on our Senate File 51, part of that discussion. That's how all of these are phrased effectively, is that they have to knowingly disseminate the information, and that's the standard that you're seeing in the rest of the legislation. Is that accurate?
That's correct, Mr. Chairman.
Okay, any other questions on the sexually
Mr.
explicit
Chairman.
material, go ahead.
Thank you, Mr. Chairman. And I'm sorry, what's your last name?
Wangan.
Wagon?
Wangan.
Wangan. Thank you, Miss Wagon. I'm so sorry.
No, you're fine.
With the current definition that we have, would using an artificial intelligence with the intention of giving the impression of sentience be considered misleading?
Ms. Wangan?
No, I am not sure. Yeah, I'm not sure. I'd have to think about that and get back to you.
Follow?
Thank you, Mr. Chairman. It's just a question going on in my community. We have we have artificial intelligence, which is in the equation in the local Cheyenne election. So I just wanted to think about that a little bit.
Thank you, Representative Singh. Mr. Co-Chairman, any questions on this one? Explicit deepfakes?
Yeah, Mr. Co-Chairman, we're curious to see how that race turns out. If Cheyenne will indeed be governing the executive branch by artificial intelligence, but I mean, the pattern I think that's a big distinction, Mr. Chairman, that you and I have emphasized is that the parody or satire component. It looks like a lot of these states have that. Ms. Wangan, would in all the legislation that you review, was there that exception for parody and satire?
Ms. Wangan, go ahead.
I believe so.
On that point, the parody or satire exception, how are they ensuring, and I realize there's a lot of different pieces of legislation here. Do you see anyone that has an appropriate process for ensuring that that isn't just simply a claim? Oh, well, we meant this is satire and therefore you're free anytime. I don't know how you would judge whether, deny that as being the truth. That becomes a bit of a challenge as a standard. Or was it just kind of blanket exemption language that tended to be in there, Ms. Wangan?
It's generally just blanket exemption, or it doesn't necessarily define any elements of satire or parody. That's generally something that the courts have determined whether or not something constitutes satire or parody in the terms of First Amendment freedom of speech cases.
Mm-hmm. So they don't have any bright line standard. It then becomes up to a court to determine whether it was satire or not, is how most of the states are handling that.
I believe so, yes.
Okay. Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. Ms. Wong, one of the things that we contemplated in our legislation was also the disclosure component in the form of a watermark, visual or audio. Was that also a consistent theme that you saw in the review of this other state's legislation?
Ms. Wangan?
Yes, Mr. Chairman, Mr. Co-Chairman, generally, it's either an affirmative defense or it just doesn't qualify as deceptive, deepfake, or synthetic media. I believe there's a few states, I think Colorado, really lays out what is an appropriate disclosure. I don't recall exactly which law it was, but there's one where it specifies if it's an audio medium, it needs to say something at the beginning that this uses synthetic media, or if it's a video, it needs to have some kind of readable text that says it's using synthetic media. And there's even guidelines for how big the text can be, what fonts can be used, and things of that like. So yes, the answer.
In so many words.
Follow, Mr. Co-Chairman. Good. Okay. Any other questions? All right. Go ahead.
Thank you,
Senator.
Mr. Chairman. So just an observation, because I think where I got stuck on our last discussion was how broad our bill was drafted. To me, these are narrowly tailored to campaign speech or things that are very related to defamation, using your image, saying things about an actual person that maybe aren't accurate. So I just want to make clear, was that the trend you also saw with your research?
Ms. Wangan?
Yes, Senator Ellis, they're generally narrowed to those specific instances.
Senator, any follow-up? Good, okay. All right. Anything else at this time? Ms. Wong, anything else?
Just there's
Please continue. Yep.
one last thing, on exceptions, we've covered
Yep.
a few of them, the ones that are consistent with federal law. And then, other state laws, I believe Minnesota's law creates an exemption for deepfakes being used for scientific or educational purposes, or dissemination by a broadcaster of some sort. So either news media, radio, if it's part of a bona fide news reporting process. But with that, I will stand for any questions.
Great. Anything on either of those? All right. Seeing none. Thank you so much. Thank you for, oh, sorry, Senator. Okay. Thank you so much. Appreciate your work on this, Ms. Wongan. Okay. Let's see. So next, we mentioned Senate File 51 and an opportunity to review Senate File 51. We went through that last time, and it's the same as it was going into the last legislative session. So I think the Select Committee is pretty aware of how that legislation is drafted. If we have any questions, we can go to it. But I think it's part of this discussion on AI. We can separate it a little bit into discussion on where we're at right now, which is discussion of misleading synthetic media deepfake legislation in Senate File 51, and take public comment directed at that, Mr. Co-Chairman, and then we'll get into that broader discussion about other topic areas that we might want to contemplate, including AI liability, data provenance, automated decision-making, after we work through the synthetic media, if that's okay. So maybe take two different sets of public opinion.
I think it makes sense. I mean, they're just different enough. I think it probably merits discussion on each individual one.
Great. All right, with that, let's open up for a general discussion, and just to step back and provide some context, right? Senate File 51 is much broader than we've heard and seen other states doing, in that it was structured to provide general civil remedy for any synthetic media that is intentionally disseminated with the intent to mislead. And so it's broader in terms of who that agent of action can be and who can bring a lawsuit against whom. It doesn't have an exemption in place in the draft that we see here today for any platforms or any other entities that are the middle providers, but it does have exemptions for FCC required exemptions, and an exemption in the language that tries to provide that the infrastructure itself is held harmless. So if all you're doing is transmitting or providing the pipeline for the data to be transmitted, that you're not responsible for the content, Mr. Co-Chairman. So we're certainly a little broader, and I think that breadth has potentially caused some concerns, but I think there's some strengths there. So this is one of the things that perhaps we want to talk through and see if there's any desires, Mr. Co-Chairman, to.
Thank you,
Go
Mr.
ahead.
Co-Chairman. I mean, I think that might be a decent time to kind of do some temperature checking. But Representative Singh, Representative Edge, you both had concerns. Have they changed? If so, what are they, or how do you guys feel about this on this issue?
That's a good question. I don't know. Representative Singh, what are your thoughts?
Thank you, Mr. Chairman. My concern has been that this bill has been too broad from the get-go. I feel if it's a broadly worded bill, that this will stray too far into First Amendment rights, and I don't feel comfortable putting something out like that. However, if we have something that's oriented specifically towards the election process, I think that's a more workable idea. Because protecting our system of government is part of the responsibilities of that government. And so, and making sure that we have an authentic election process is an essential function of government. And so I realize that. But I would hate to see any sort of infringement on the First Amendment.
Thank you, Representative Singh. Representative Andrew, what are your thoughts?
Thank you, Mr. Chairman. I'm probably going to remain, against this concept and against the bill. I still think that the most appropriate way to handle these kind of things remains through our system of common law. And I think that moving this into the criminal realm probably goes a little bit too far.
On the criminal realm, just following up, if the criminal violation is removed and it's strictly civil, what are your thoughts at that point?
Thank you, Mr. Chairman. I think that would probably be better. I'd still probably remain a no on the bill as a whole.
Thank you. Looking to the Select Committee online. I know Representative Yin's out there. I think Senator Furphy may still be there. And anyone want to jump in that we have online and share your thoughts on what direction we should be going with this? We can also go to public comment relatively soon and see what we're hearing back for feedback as well. Mr. Pope, go ahead.
Thank you, Mr. Chairman. I remain in favor of this bill. As I've testified before, I think one of the things it does is it lowers the threshold and bar for someone to be able to actually go to court and bring in action to at least be compensated for this. The criminal element, I'm not. That's something that if it was not part of that, that would be great. I think right now our common law sets the bar so high for someone to truly take action in this area that I love the protections that it gives to the common person, and not just in the political process. So that's really all I have to say on it.
Thank you, Mr. Pope. Anyone else want to weigh in at this point? And we'll take public comment as well, so we don't have to chime in right now, but make sure we get everybody who wants to speak. Senator Nethercott.
Mr. Chairman, similar to last year in the interim and this last session, I support the bill and support the effort.
Thank you, Senator Nethercott. Anyone else? All right, at this time, seeing none, let's go to public comment and yeah, go ahead. Sorry, Senator Ellis.
I didn't know if you wanted to take my temperature.
Oh, yeah, absolutely.
Please.
I would really like us to focus on the campaign piece of it and in segments, just because of the harm. I think that hasn't been flushed out. And I've thought a lot about this and trying to communicate my concern. At the end of the day, we're talking about not just speech, but your expression. So if you think of an artist back in the 1600s when they're painting canvases and they're trying to depict an image, that's the medium that they used. And are they trying to deceive in showing you a bowl of fruit or whatever? I don't know. But the point of it is AI is, to me, just like an artist canvas. That's a tool that people use to express an idea. And so if we're going to regulate speech, and that's why we do it in the form of campaigns, for elections, for marketing, and for defamation, we're really cautious on regulating expression. And so we do it in very, targeted ways. And so if I were to have a preference, it would be to take some of the concepts in that bill and really focus and apply them, one, to campaigns, one, if we wanted to do truth in advertising, and then three, in the defamation world. And I think Emily's memo really breaks it out clearly in that regard. But I think that's why this has me so nervous, is it's too broad and we shouldn't be broadly regulating speech.
Thank you, Senator. Any additional thoughts before we go to public comment? All right. With that, let's open it up for public comments. Do we have anyone in the room that would like to provide public testimony? Agencies first, if any agencies want to weigh in at this point? Not seeing any. Anyone in the room more broadly? All right, with that, let's go online. And let's start. Let's see, who do we have specifically for this one? Excellent. Okay, very good. Let's go in that order then. Let's start with Mr. Greenwood on this bill. Talk to him a little bit and then go to Ms. Barco and Ms. Beller. So we can bring in Daza.
Mr. Chairman,
Daza, good to see you.
thank you. It's a pleasure to be here. Hello, members of the Select Committee. Jet, I don't have a lot to say on this bill beyond my testimony at the last session. I think the only thing I would emphasize is I do think it's important in the exceptions that cover First Amendment, just to make sure that there's no interpretation of them that somehow is going to allow things like parody or satire or that sort of stuff somehow slip through the cracks, because that's where I think one of the battle lines is going to be, and that's an opportunity for over enforcement. Thank you.
Great, thanks. And Daza, have you seen anything, since we last met, any of the legislation that you see out there that Ms. Wangan raised that looks like it does the job or hits the mark? I'm concerned with a lot of them being structured in a way that looks like it's going to achieve something, but at the end of the day is generally easily avoided. That they're written with robust loopholes, I'll say, and can just be worked around. That's one of the concerns that we've discussed. Do you see any that maybe you've interacted with their legislatures or that you've been talking about in your community that rise above?
Mr. Chairman, no, I have not. I think and that's interesting to note. I think one of the things I draw from that is that this is a difficult area to legislate. And as the person testifying mentioned, it's a new area, and that may be part of it. And it's regulating a new type of technology and a new type of capability, and mostly hypothetical harms. And so I think one of the things I draw from this is perhaps to take a closer look at existing areas of law that can apply in common law and other parts of statutes and regs, and see how good a job they might do in the interim until more clearly demonstrated harms emerge, where a gap could be identified and more narrowly legislated to remedy.
Thank you, Mr. Greenwood. Any questions for Daza? Questions? Go ahead, Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. Daz, at this point, you're an old friend of the committee, and we appreciate all your patience. My question to you is, and I think, Mr. Co-Chairman and I have had this discussion, ad nauseum at this point, but I feel that you talk about common law and how obviously this has been around for many, many years, but the distinction is that, you have your right to your own free speech, but not to the free speech of others, meaning I can't make a video saying this is Daza being portrayed as Daza saying and doing, X, Y, and Z, and that the right to somebody else's free speech is not included either in common law or otherwise. I mean, do you feel that that's a fair delineator of how to describe this, or are we missing the mark a little bit?
Mr. Greenwood, go ahead.
Thank you. Mr. Co-Chairman, I do think that's a fair delimiter. And at the same time, I think it's appropriate to look at existing legal frameworks that may apply. So I'm thinking of impersonation and criminal impersonation under Wyoming laws, for example, and other prohibitions on fraud and so forth, and theft potentially, depending on how you define the asset that is one's identity. I think there's some creative causes of action that law enforcement and that individuals in the private sector may have that they can avail themselves of. Having said that, and I apologize, I have not looked at the most recent draft, but the draft as it was at the end of the last hearing, to me seemed net positive. I'm unaware of a better draft out there, and it seemed like you're going a good direction and you're being very thoughtful about it. There is fire here. Like, we are seeing the harbingers of this technology being used in ways that are harmful. It was mentioned, in an election, the narrower the context, I think the easier it will be to articulate something that's less likely to have unintentional consequences. And elections are the thing at the top of my mind, I think many people's minds. So I do think that's a good delineator. And I also think that on the side of the delineation you're talking about, there may well be existing legal frameworks that could do the job.
Thank you, Mr. Greenwood. Senator Nethercott, question?
Yes, thank you, Mr. Chairman. I heard the comment from Mr. Greenwood, and I heard the comment, I believe, from Representative Andrew. What common law principles apply? Because I'm struggling with coming up them, but both of you referenced them with confidence, and just curious as to what you think actually would apply in this circumstance. And let's limit it to even campaigns. So let's say someone does a deep fake on a political candidate. What common law cause of action would apply if everyone feels so confident that there's something else?
Thank you, Senator Nethercott. Mr. Greenwood, any thoughts?
Yes, I think it depends on the circumstances, which is partly why I was leaning on there being advantage to narrowing the scope to particular domains. But like one example, I'm thinking about the case in Australia where somebody was misportrayed and it caused them a great deal of distress. So you have intentional infliction of, emotional distress, for example, as a adjacent cause of action that can provide a remedy potentially. I think I didn't really lean so much on common law. I'm thinking about statutory remedies, and the one that I was really pointing at more specifically was criminal impersonation. And when I say common law, what I'm waving my hand at is, depending on the specific circumstances, plaintiffs' lawyers can be very clever, more clever than me. I am not a litigator, nor am I a scholar in the common law, but I know that it's possible to fashion equitable remedies that meet the circumstances. And that's something that's part of Wyoming law when you carried forward common law and the ability to come up with novel equitable remedies that I was mentioning. So things that can fit the specific circumstances at a broad stroke is what I was referring to. I'm not here talking about common law primarily. I'm really talking about existing statutory and regulatory frameworks.
Yeah, Mr. Chairman,
Mr. Greenwood, follow up. Go ahead, Senator.
Yeah, thank you. I think that's a really interesting concept, but I want to kind of reframe the issue, or at least bring up for the conversation this issue of harm. And so, Mr. Greenwood is mentioning harm to the political candidate. And I certainly care about the candidate deeply. But I think when we're talking about campaigns, what we're really concerned about is harm to the public, right? And so does the public then have this common law cause of action for intentional infliction of emotional distress? Certainly they do not, no. And so I think due to the uniqueness of the times that we are in, and the danger that can be perpetrated and is being perpetrated, that a deterrent beyond a plaintiff's lawyer's creativity is important for the protection of the public, which is why we create laws, and to provide remedies in that way. So in some ways, you need to understand the harm, and typically in a private right of action, when we're referring to the common law, the only person who could bring that cause of action is the potential candidate. And again, I want to mention that candidate no doubt is harmed. They may lose an election, their reputation may be damaged, but the harm we're trying to prevent, in addition to the candidate, is that harm to the public.
Yeah, Senator Nethercott, that's well said. Mr. Greenwood, response?
Thank you, Mr. Chairman.
Not that you're obligated.
No worries. Thank you, Mr. Chairman. Senator Nethercott. Of course. And, again, I defer to you as the only, I was a candidate at local in my much younger days, but you're the person who can speak best on so many of these matters. My only reflection on it would be, within campaign, laws that relate to elections in Massachusetts, which is the only place I'm really familiar, and just vaguely at the federal level, I would look first to see what in there may apply in terms of some sort of election interference or intermeddling. And just again, just the principle at a high level is an audit, narrowing the scope as you just did to elections, really good. And then an audit of existing laws to see how many of the foreseeable and especially the already demonstrated harms may be covered. And then where's the gap? And then to legislate to the gap is sort of what I'm saying.
Senator Nethercott, any follow-up?
Yeah, Mr. Chairman, I agree with the desire and the need to narrow it down in scope at this point in time until we have a greater understanding of this issue. The challenge with campaigns, which we all feel compelled to do, they have the highest level of First Amendment protections. So I think Senator Ellis mentioned different speech has different types of protections, all of it protected by the First Amendment, usually, most of the time, but political speech having the greatest level of protection. And so what we're choosing to do by narrowly tailoring it to that speech, we think that we're providing maybe some type of constitutional buffer, but in reality, we're laser focusing it in on the highest level of protections on the First Amendment balance. So just being mindful of that.
Good point, Senator Nethercott. I think Representative Andrew, did you want to weigh in? You good? Okay. Any other questions for Mr. Greenwood before he leaves? All right, seeing none at this time, we know that we've got you queued up in a little bit, so we'll see you in a moment, Mr. Greenwood. Thank you.
Thank you.
All right, I think we have Ms. Barco next. Yep, I see her coming on. Ms. Barco, good to see you. Please identify yourself. The floor is yours.
Thank you, Mr. Chairman. My name is Ruthie Barco. I represent TechNet. We are a national bipartisan network of technology CEOs and senior executives that promotes the growth of the innovation economy. Our diverse membership includes American businesses in the fields of information technology, artificial intelligence, e-commerce, sharing and gig economies, advanced energy, transportation, cybersecurity, venture capital, and finance. We voiced our concerns on this bill during the interim, but then also during the 2024 session. So we really appreciate the committee allowing for additional discussion on this bill. TechNet supports the clear disclosure by the creators of especially political content that is created in whole or in part by generative artificial intelligence tools. Wyomingites and US voters at large deserve to know whether or not campaign content is authentic or not. TechNet, of course, supports the adoption of federal regulation that would bring uniformity on this topic to all Americans to ensure that voters in national elections have confidence that the information they receive about candidates is accurate and reliable. But in the absence of such a federal framework, it is critical to promote uniformity with other states. We appreciate the Select Committee taking time to survey what other states have done. TechNet is working and has worked already in the past session on dozens of bills on this topic around the country. I alone worked on bills in Colorado, Oklahoma, Missouri, Kansas on this topic. And we stress that this is not a topic where a state should enact outline legislation and that interoperability between state laws is critical. We maintain that several points in the bill must be corrected before being considered for an introduction vote on Senate File 0051. This bill requires clarification simply to ensure that it cannot be applied in an overly broad manner, as we believe the current language allows right now. We do think that it could also be further aligned with other states by these changes. Our suggestions are as follows. We agree with the legislator concerns that have been voiced during discussion by legislators today. We do agree that a broadly worded bill does result in First Amendment overreach. We therefore agree with the comments that a campaign related materials would be a better focus for this bill that would eliminate a great deal of that risk. As such, it must either include an exemption for the distributor of the content or a platform that has no role in creating the content in question, or clarify that only the content creator can be found liable. Every platform pretty much has an option, whether it's from an ad perspective or social media, to allow the content creator or the poster to flag whether or not the material is AI created. That's becoming pretty pervasive and standard now, but we don't think that necessarily means that there should be liability for content creators and platforms. I'm sorry, for platforms. Adding natural before person in paragraph B would help make clear that only the creator or sponsor of the content in question can violate the law by not adding a disclosure. We also think that where it says visual disclosure is not feasible, in paragraph B, little I, capital B, to help ensure that platforms and the websites are in compliance for including a visual disclosure on platforms where only audio recording is accessed. We think that this is an area where compliance could be difficult and clarification could help. We also find that the audio disclosures were a little prescriptive. You know, if every state passes a different interpretation of what these disclosures should look like, you end up with a patchwork of conflicting state disclosure requirements, which can get very difficult for a 50-state compliance framework. It would be prudent to add exemptions for the use of AI and machine learning for cybersecurity and anti-fraud purposes, as they are critical applications here. Other states have added those in different manners. I'd be happy to report back on that. And we cannot support a private right of action as is in the current scope of the bill, which is obviously broader beyond campaign-related activities. We could circle back on that. So we were previously asking for paragraph C to be removed in its entirety. If this is limited to campaign-related materials only, that obviously changes that. For instance, Colorado had a public mechanism where written complaints could be filed, I believe, with the Attorney General's office in House Bill 241147. But candidates were the only ones who had a cause of action. And I believe that echoes where Senator Nethercott was discussing. We thank you for consideration of our concerns and our perspective. We look forward to continuing to work with the legislature on this issue to ensure that legislation is tailored and enforceable and does not infringe on the First Amendment. Thank you.
Thank you, Ms. Barco. Questions for Ms. Barco? Go ahead, Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. Ms. Barco. So to what extent do these creators or to what level is their liability exposure? What should it be? I mean, I'm looking at your members. You've got OpenAI, you've got Google, you've got these platforms. They can, of course, be used for great benefit, but can also be used for pretty pernicious intentions. So to what extent should these platforms be liable, or should they be liable at all, in your opinion?
Ms. Barco, go ahead.
Thank you, Mr. Chairman. This is an evolving area of law on very quickly evolving technology. So I understand that the focus of the discussion of this committee has been looking at platform liability. I was thinking about this from the context of, is it a parallel situation where your bank doesn't find in time that they flagged fraudulent activity on your account? So they take care of that when you flag it, they take the transaction down, but does the bank actually need to be liable for the fact that that transaction happened when they had all the tools and mechanisms in place from a cybersecurity perspective to try to flag those transactions while they happen? I think if we're allowing for platforms to provide for identification of AI related materials, and, you know, they're trying to comply with these laws in good faith, which is why we're asking that there is not a 50-state patchwork of conflicting laws on what the disclosures and disclaimers are. We think that it is on the burden of, you know, enforcement mechanisms to ensure that the content creators who are creating content that is a deep fake and a malicious intent, those can be identified, and they have been in the past. That's also why we're asking for cybersecurity and fraud exemptions, because you are actually using AI tools in many respects to actually, the best way to identify AI is sometimes with a cybersecurity AI tool. So that's where we were looking for ensuring that that was not wrapped up in enforcement.
On that point, real quickly, before I go back to the co-chairman, Ms. Barco, where do you see this legislation running afoul of that? I can't fathom a circumstance where anything you just described would fall under misleading synthetic media as defined in this legislation.
Oh, thank you, Mr. Chairman. From a cybersecurity standpoint?
Well, what you just described as a desired exemption, I just can't see how it would possibly be considered by the way this bill is drafted. Maybe other bills that you've seen, but I just don't see how it would run afoul of intentionally disseminating information meant to mislead the public based on artificially generated, you know, synthetic media, which is the focus of this bill. So what are you reading into this legislation that would suggest that it needs to be exempt from that. I'm missing that connection.
Thank you, Mr. Chairman. Yes, because this is such a quickly developing area of law, I think there is a concern in making sure that it cannot be misinterpreted from a standpoint when we are all trying to find ways to combat nefarious activity using deepfakes. I mean, remember too, this isn't just with campaign related materials. There are deepfakes where they're using people's voices to get to access their bank accounts, things like that. And I think this was more from a perspective of this is developing so quickly as an area of technology, that exemption, even if we cannot necessarily interpret how it would be wrapped up here, I think it was more of protecting the development of that technology because it is an excellent resource in this fight to combat nefarious activities. And I'm happy to report back further on that to the committee.
Yeah, maybe a little more clarification on that. I'm still not following how it might run afoul of the legislation as it's currently drafted or as has been described. So thank you, Mr. Co-Chairman. Follow up. Okay. Any additional questions, Select Committee? Ms. Barco, I have one more that I'm curious about. And one of the concerns that you've heard us talk about is that a lot of the other legislation looks like it does something, but really doesn't do very much. It doesn't provide protections because there are enough loopholes and because, as you noted, this technology is evolving very quickly. I would think it would almost be trivial to walk around any of the bills that we had described today because they're narrowly tailored, as you suggested was desirable, but narrowly tailored enough that it would be very easy just to evade that. Are you seeing in your work, any real solutions or anything that has been headed off by any of these bills that have been passed that otherwise would have happened? I just am surprised to see this many bills passed that, in my opinion, as a legislator, don't really get to the heart of the challenge.
Thank you, Mr. Chairman. I appreciate the question. You are right that this is a big challenge, especially when we were talking about whether or not voters, national elections, local elections, whether or not they're able to trust the campaign related content that they're seeing. That alone is a big challenge. And then when you broaden that beyond, we are concerned that if states are too aggressive with how they draft legislation, targeting technology that's moving extremely quickly, we don't want to be in a scenario where legislation paints a state into a corner with how these technologies can operate in a state. And I think it was very interesting with some of the discussion in the interim where you have very small startups in, I think Casper, Wyoming, calling in and talking about the work that they were doing. This is moving so quickly. With the Colorado bill, there were a lot of startups that got engaged with Senate Bill 205 that I don't know that anyone really understood were actually operating in Colorado. There's a lot going on in this space. Any bill can really be amended in future years. And if these are housed in areas of state code, that can be expanded and broadened. And we have found that an incremental approach to AI legislation equips the state the best to deal with these challenges as they develop and evolve, which is inevitable. They're developing and evolving all the time. So we think that states and state legislators specifically should use the power that they have to continue to work on these issues. Any piece of AI legislation that you see is not going to be the final form of that piece of AI legislation, or that, because once it gets into code, there are inevitably going to be changes that will be necessary as time goes on. So I think I heard one legislator talking about it at NCSL, or I think a forum on AI, saying that, we're at the beginning of square one of AI legislation. This is not a 1 year or an election cycle focus on AI. This is going to be the next decade of focus on legislation. So we do think an incremental approach equips states the best to respond.
Any follow-up on that, anyone? Thank you, Ms. Barco. And, I certainly agree with the approach that we're going to need to evolve this legislation as AI evolves. The concern I have really right now in getting to the prior question is that passing legislation that just looks like we've done something, but that doesn't actually change the outcome of what ends up happening is a concern that I have. And as I look at the legislation that passed other states, I really don't think any of them have enough teeth to dissuade a bad actor from doing bad things. The workarounds are so straightforward. And when you only hold a creator responsible, we'll never find the creators of these. That would be the first thing you would do, is just hide who the creator is. So I guess I'm challenged to understand how the increments that have been put forward, that have been worked on in other states that you've worked with, will do anything to change the amount of misleading synthetic media that we see in the upcoming election or in the years ahead. What can you present me with to the contrary, where you can point to a really good piece of legislation that is definitely going to lead to better outcomes in either an election or in a state, based on the structure of that? And how is it tailored so that it will provide that type of protection?
Yes, Mr. Chairman. I think the timeline on this has been moving very quickly. So was it last, I'm going to get these dates wrong. I can follow back with documentation here, but was it last summer that, was it a 50 state attorney general letter that was a cease and desist letter to whatever creator that they were able to identify the creator of the President Biden deepfake calls, the robocalls that went out in New Hampshire. And it resulted in a 50 state, I believe it was all 50 attorney generals that signed on with that cease and desist. I think when a state at least starts codifying the legal terms and the definitions and the enforceability around these cognizable harms, that is an excellent step to be able to build on that, whether further enforcement is needed, whether better definitions. One member of the committee, and I couldn't see who it was, voiced that this is very difficult to legislate and very difficult to define terms, is what I believe I heard them say. And it very much is. I think that half the challenge that you're seeing with Colorado Senate Bill 205 being the first omnibus AI regulation to pass in a state legislature, there's still a lot of ongoing discussion about whether or not those definitions are right, whether or not the way that actually is structured provides both enforceable help to people, or is it too far that it is hurting innovation, which there was a lot of reporting in local media. So I think that starting out with what some of these state bills did, you mentioned Colorado 1147 is the one that I'm the most familiar with. But I think it would go to a forum if candidates feel that they at least having a cause of action as a candidate to be able to bring this to the Attorney General. Is that a good enough step? Do we think that helps? And I think this election will be absolutely a test case for how this works.
Thank you, Ms. Barco. Just one more question. What about the case that we have described? Most of the legislation gets at the straightforward, I'm a bad actor that I create a deep fake of candidate A that is negative against candidate A, and then candidate A has a cause of action against the creator. I don't know that anyone has to stop disseminating it, but candidate A could go back and sue the creator. That's pretty straightforward, and that's what most of the bills do. What about a case where instead of attacking candidate A, as we've often discussed, I create a positive false image of candidate B, and you don't know the creator? Which bill covers either half of that scenario?
Well, I think the presupposition that, thank you, Mr. Chairman. I think the presupposition that we would not be able to identify the content creator, I don't know how that could be enforced at all. I think that becomes a question about, this gets into a broader discussion even about some of the things that the Supreme Court spoke on today with social media. A lot of these platforms have gone into great detail about what they even do to take down general content that they find harmful. So I think it becomes part of that discussion, and that is absolutely where it gets into First Amendment territory. I think we all collectively agree that there is a social responsibility to ensure that content is properly labeled, whether it's positive or negative. And I think that's where we're at right now as we understand where this comes from. And I don't know that it's simply the binary of one candidate versus another. to your point about a content creator and if they're unknown, it is possible to find out where the content creator is, where it's come from, but this may not even necessarily be domestic. You're talking sometimes international engagement on some of these. I mean, we don't really know the scope of where this is, and it is widely possible. So that further underlines our concern that we want to make sure that we're equipping technological development in the United States to be a leader in artificial intelligence. So that's why we want to make sure that these bills are not overly broad, because, you know, we may be writing bills right now for Wyoming, but if something is hosted from outside of the domestic United States, we want to make sure that that is also actionable. And right now we're starting with identifying it, making sure it's properly labeled in legal terms, enforceable. And I can get back to you with more specifics about the state laws. Unfortunately, there is such a patchwork of which one is enforced how and the definitions. TechNet's message on all of these has been just very consistent. We want to make sure that it is not hindering compliance in good faith. That's what we've been focusing on.
Thank you, Ms. Barco. Any further questions for Ms. Barco? Seeing none, thank you so much. Appreciate your participation once again today. All right. Next, we have Ms. Beller. Please introduce yourself. The floor is yours.
Hi, thank you so much. I'm Ilana Beller. I'm with Public Citizen. We're a nonpartisan organization, and we have been working extensively on this issue. We've worked with state legislators in over 30 states across the country on this type of legislation at this point, and have seen a lot of different ways that states have gone about this. So a couple of things. I wanted to start by making two small suggestions to the bill as it stands, or as it was standing as of kind of when the session ended, sorry, SF 51. One that we would highly recommend including an exemption for satire and parody for the reason of potential First Amendment concerns. We do just think that this is necessary in order to address any potential First Amendment concerns that may be raised. And then it sounded like you all were discussing a window as well. I know, I heard earlier that you were looking at what other states were doing there, and states have done a range of things. Some states do not include a window. Others include a 30, 60, 90, or 180-day window. There's a variation across the country. And this is something that we have been recommending to address any potential First Amendment concerns as well. But again, we've seen a range there, and we feel that it is less important than the exemption for satire and parody. And then I did just want to address some of the kind of questions and concerns that were raised. First of all, I did want to make it clear that we feel very strongly that with the current law that exists in this space, deepfakes would be circulated without any consequences in many cases. So I know folks brought up common law and other examples, like in New Hampshire, how they were ultimately able to address the actions that were done there. And I will say in that specific situation, that was because many states have laws on the books that make it such that it is not legal to lie about in a way that would prevent people from voting. So lying about the location or timing of an election. But in most cases that we would see and that we're seeing in other countries and what we're starting to see in the United States would not be covered by current laws that exists. I do also want to address a couple of other things. I know that there some concerns were raised about Colorado Bill SB 205, and it was noted that folks raised a lot of discussion around that bill, and that was not the bill that regulated deepfakes in elections in Colorado. I think ultimately the bill that does regulate deepfakes in elections now in Colorado was mentioned 1147. But I did just want to clarify the bill that brought on more discussion was not that piece of legislation. It was a different piece of legislation, and it was a broader bill. There was also a recommendation or a suggestion that liability should be on the creator. And I think this was Senator Rothfuss, you got at this in some of your questioning, but it we highly recommend that the liability is on the distributor, not the creator. For the reason that you mentioned, which is that it would be difficult in many cases to know who the creator was, but also it's not clear that in all cases the creator would want what they created to be disseminated. And so it is very important that the liability remains on the, or it remained because the way your bill is written now, but would be on the distributor. And then let me see what else. So the other thing that I would like to specifically mention, and then I'm happy to take any questions, is just that we have seen pretty broad exemptions be made in a lot of states for broadcasters and other kind of middlemen, as you called them earlier. And one of the recommendations we have there would absolutely to include a requirement for broadcasters and others in that position to make a good faith effort to establish that the content that is being given to them by the sponsors of the content was not in fact a deep fake. And we do definitely have concerns that some of the laws that have been passed would allow for broadcasters to knowingly circulate a deep fake, which is absolutely not what we want to be the case. And of course, there are some federal regulations that make it such that, if a broadcaster is paid by a candidate specifically to air an ad, they must do so. And but that would not cover PACs, for example. And so now there are some laws that have created a big loophole for PACs and others. So I know that was a bit in the weeds, but I think a lot has been said that I would have said otherwise. I think, you all already know the case for why this is very important. And I think the main thing I wanted to do here was just give our two kind of minor suggestions. I would say the satire and parody exemption is actually quite important. But other than that, just address some of the other things that I've heard being said. And then again, I'm familiar with a lot of these laws, worked very intensively in many states on this legislation, and I'm happy to try and answer other questions that folks may have if I can be of help. So that's all I have. Thank you.
Thank you, Ms. Beller. Questions? Go ahead, Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. Ms. Beller, I can appreciate your need to have more explicit language for in the case of satire, but do you not think that what we have in here wouldn't cover that so long as you put that disclaimer on there?
Go ahead, Ms. Beller.
Yeah, so I think that's a great question. The reason we are making that recommendation is specifically because there is so much, as Senator Nethercott mentioned, so much scrutiny when it comes to First Amendment law in the realm of political speech. That is just kind of a baseline exemption that is recommended by our lawyers in order to avoid potential pushback or scrutiny in the realm of First Amendment.
Follow-up, Mr. Chairman?
No.
So my question is a bit of follow-up on that, is the way this bill is structured tries to get at that intent side, and you have under the definition language that that includes, this is page 2, line 10, that to a reasonable person is of a real natural person in appearance, action, or speech, which appearance, action, or speech did not actually occur, and which would cause a reasonable person to believe the appearance, action, or speech occurred. Part of the intent with that definition was to avoid it incorporating satire or parody, which shouldn't fall inside that definition. And a previous discussion that we had last year on the committee was if you had an explicit exemption for satire and parody, then that would just be the vehicle everyone would use as saying, oh, well, this was obviously satire. It wouldn't be satire. That wasn't the intent, but I would simply say that, and that would take care of it. How has that been handled, or what are your thoughts on that concern that we discussed?
Yeah, it's a great question. So in terms of how it's been handled, for the most part, states have included an exemption for satire and parody. Public Citizen actually tracks all of the laws that have been passed, the legislation of this type that have been passed. And I will mention 20 bills now have been passed, and most of them do include that exemption for satire and parody. In terms of and have similar definitions, I should say, for deep fakes or synthetic media or whatever term they are using. In terms of your question legally, I'm not a lawyer. I'm happy to bring that to our lawyers. I did run my recommendations by our lawyers, and they agreed with me that they felt that the satire and parody exemption was needed in this case, but I'm happy to bring this back to them and get a more full answer, or have them engage with you directly, just so that you can have as much clarity as you would like. Unfortunately, I can't give that to you because I'm not a lawyer.
No worries, Ms. Miller. And along those lines, you would have a circumstance where the creator would have created it for parody or satire, and it had a limited release, we'll say. And then you have massive viral propagation and distribution of it as if it's true. And those are obviously two very different things. The way this legislation is structured, the intent was to basically cover that second example where you have an intent to mislead, but the creator would actually be held harmless because they didn't disseminate it with that intent. That was the intent here. So yeah, if you would visit back with your folks and kind of walk through that scenario, that's one that we toyed with, and I don't know the solution to it.
Yeah, and I've heard this come up once or twice in other situations in committee, and I think it's a good question, and I'm happy to get back to you on it.
And Ms. Beller, a quick question. Is your organization primarily working on deepfake related legislation with regard to elections or more broadly?
So we are working on deepfake legislation with regards to elections, and we've been working extensively in that realm. We are starting to support some states with intimate deepfake legislation as well. And we are only looking at those two realms currently. Although we do have legal experts who may be able to help more broadly in specific situations. We're not generally making that offer, but we would be happy to help in this instance. So yeah, if there's anything we can be helpful with here, we'd be happy to. I would not be the person to help with that. Our president, Rob Weissman, would, but he's generally
great.
Happy to help. Yeah.
Thank you, Ms. Miller.
Yeah, of course.
The other question that I would have regarding the other legislation that you've seen gets back to the question I was asking Ms. Barco, which is, I know a lot have been passed, 20 have been passed. I just don't feel like they will be effective in achieving their objectives because they are heavily loopholed and so many exemptions and so narrow that it seems like it would be easy to circumvent the scenario Ms. Barco was laying out. For example, you have an actor in another country that is intentionally trying to influence an outcome. They're obviously not going to be easily found and brought to justice. And so then it would be a matter of going through the platform and propagating that information that might be deceptive. Certainly, you could simply make it a favorable video instead of an unfavorable video. And I think that little scenario I laid out circumvents every law that's going into effect. And also, I'll go ahead and release it 61 days before the 60-day timeline, just for good measure. Is that accurate? Am I missing something here?
Yeah, so a couple of things on that. I think the foreign bad actor question is an important question, and it's a difficult one, to be honest. I think, one, it is very good, and I actually had meant to speak to a couple of the strengths of your bill, because generally we think the bill that you had this past session was very strong. And I'm sorry, I feel like, just only talking about the bad here. But the injunctive relief piece of what you have is very important, because part of this, yes, it would be very hard to dissuade a foreign bad actor from circulating a deep fake. The injunctive relief piece is very important because it at least provides an avenue for quickly, taking down these deep fakes. And that will be very valuable, especially very close to the election, which is, for example, what we saw in Slovakia, where there was a deep fake circulated within 2 days of an election that was widely viewed, and, they weren't able to dispel or take it down. And so that injunctive relief piece does help in the foreign bad actor situation. It doesn't, however, prevent someone or, dissuade someone for putting one up. I do think also, one area where I do agree with Ms. Barco is that we don't know exactly what these threats will look like. But a lot of what we are seeing currently is the dissemination of deepfakes utilizing social media. And in that case, I agree with you that there are a lot of loopholes that we're seeing. We're seeing folks create, push for a lot of loopholes, especially for broadcasters and other type of middle men. But a lot of what we are seeing is taking place on social media. And so, in that case, it is those loopholes aren't as present for like an individual person or someone who, has a large following on social media. A lot of the laws that are standing would allow for A, the content to be taken down, and B, for that distributor to be held liable. And so that is really valuable. And again, we are seeing a lot of the deepfakes that we're seeing as of this point kind of coming through in that context. And so I wouldn't say that they are unimportant laws or that they are not going to cover a lot of the situations, but there are certainly a lot of situations that they don't cover, if that makes sense.
Sure, that's helpful. Thank you. Any further questions from Ms. Beller? Anyone online have their hand up that I don't see? Okay. Thank you so much. We really appreciate your testimony and for joining us today, and look forward to continuing work as we work on this issue. Thank you so much.
Awesome. Thank you.
All right. Do we have anyone else right now? Is Ms. Wilkinson or Mr. McNiven available at this time? Okay. Excellent. So no other public testimony online for this topic. Any other public testimony in the room on this topic? Okay, seeing none, let's close public testimony. Come back to the committee just for discussion again on what direction we want to go, where I think there's been a lot of discussion on various directions. Is there any other work or action we want to take? I think there's a lot of differing views on what to do with Senate File 51, but Senator Ellis, anything else to add from your previous comments?
No, Mr. Chairman, other than I just don't know where we're headed. As we talk about the bill, we tend to gravitate toward the political speech regulation. If we go down that path, I think we look at our statutes, we look at how other states do it, we think of the scenarios, and I think we can address that. But then I start getting lost when we start blending in concepts of defamation, because that's a different set of remedies, different requirements, different concepts of law. My preference really would be to try and get this out of the new title or the title that it's placed in and put it in the election title and start narrowing in on all of the what ifs there. But I don't know if you feel that way, Mr. Chairman, but I feel like that's where we keep gravitating the conversation, I think. And to Senator Nethercott's point, it isn't regulating it for the candidate, it's regulating it for the public. That's why we regulate that type of speech. Defamation's a whole different thing. That usually involves the harm element, right? Like you say something about who I am and my profession, is it harming my work? But that's a different analysis with different considerations. So I just think having it all together, trying to fix all these problems in one bill with too many legal concepts is just, I don't think we'll ever get our arms around it.
Thank you, Senator. Any discussion on Senator Nethercott's points before we kind of hear from others? Thoughts on Senator Nethercott's? Go ahead, Representative Singh.
Thank you, Mr. Chairman. I thought that
Senator Ellis, did I say Nethercott? Senator Ellis, go ahead.
that Senator Nethercott's points were very powerful. That is true. Political speech is protected, the most protected speech in the United States, and it's been that way since the get-go intentionally, because their government inflicted violence upon them
Mhm.
because they didn't say the political things that they were supposed to. And so that was a very powerful point. Thank you for making that.
Thank you, Representative Singh. Any other thoughts? Discussion on Senator Ellis's thought of presumably narrowing it, Senator Ellis, and trying to get to one or, well, really it would be three bills, but we wouldn't necessarily do all of them, kind of in the concept, getting to an election related bill and others. Mr. Co-Chairman, thoughts on Senator Ellis's suggestion?
Thank you, Mr. Co-Chairman. Yeah, I don't want to kind of rehash what's been said. It certainly seems that the importance of this issue and the immediacy of this issue is apparent to everybody. I think there's a high level of consensus on that. Not a lot of consensus around the bill as it's currently drafted or the engrossed version that we certainly saw. So I think if we want to get something out of this, the select committee and get into the next session, probably having one that's stripped down specifically just for the political component seems like that's the best path forward, at least as of right now.
Senator Ellis, what if this bill, out of curiosity, and maybe this is putting you too much on the spot, what if the entire bill were tailored so that it was referencing related to political elections, something along those lines, without much other change? And you'd obviously then remove we have a paragraph that would need to be removed, which is the one that's basically remove the criminal provision, which is page 5, paragraph G. And then everything else stays effectively the same, but then we just kind of change it to an election related bill. Do you think the structure of it works for an election related specific bill?
Thank you, Mr. Chairman. I think, that's a better question for LSO, who will have to, I think it should be in Title 22. And then I think we'll have to comb through it to see, how well it fits with other provisions in there. I never served on corporations, but, we do have, I think, criminal and civil remedies in Title 22 for elections. And so I think it would just be like really combing through it and say which concepts of this are similar to what's already in statute and see how they marry and match up. And then who enforces it? When we have candidates that try and seek court remedies, I think courts are really resistant to get involved. I think they, usually say, is this a political question that should be involving your branch of government? We're staying out of it. Versus, is it something beyond that where the court's like, no, here's the statute, the public's being harmed. It's not just a candidate bringing the issue. What's the intervention? I think I think we get a lot closer to having some more meaningful conversations. So to answer your question, but not, I think it gets us closer, but I just haven't studied how this would fit in Title 22.
Understood. Go ahead, Mr. Co-Chairman.
Mr. Co-Chairman, I certainly, piggybacking on Senator Ellis's comments, I certainly wouldn't want to prevent a candidate from being able to pursue action. I could certainly appreciate they don't want to be initiating action, but we also don't want to prevent them from being able to do so as well.
Thank you, Mr. Chairman. And I think this would, again, Senator Ellis is exactly right. You'd have to go in and restructure the language a little bit if you're putting it in the election statutes, but I think overall it would still all work just fine if it were in that part of the statute and specifically relevant to elections. The one concern I have, well, there are several concerns I have, but we'll just say one concern I have with tailoring it to elections is just how narrow that is compared to what actually affects an election. And like everything else in election law, where we really do see loophole exploited after loophole exploited, and you have people that are literally being paid to find loopholes to exploit in the election realm. When we create a topic area that's off limits, all I have to do is modify it just a little bit, and it's no longer about a specific candidate in a negative way. I'm providing misinformation maybe about circumstances that would influence the public and the election. And I'll be off the hook. So as written now, it's hard to work around it based on content alone, but that does provide an opportunity. Although at the same time, it would provide, you'd have to go indirect instead of direct, which would be an advantage relative to where we are now. Senator Nethercott, I see you coming on the screen. Do you want to weigh in on your thoughts on this potential approach?
Yes, I just want to, I mean, this is such an interesting topic and we have time and I think this needs to continue to be worked. So
Yeah.
Focusing in on campaigns, right? And our concern is using deep fakes to mislead the public in some kind of way.
Right.
And so our committee is dealing with this topic as it relates to the use of a deep fake. But the harm that we're trying to prevent can be done using a variety of means, not including deep fakes. So that's why it's not in Title 22. That's why it's not in the election code, because it is political speech. I mean, let's say, for example, you had a candidate being accused of being sued for lying, for example, and that was completely untrue, a complete falsehood. And that harmed the public's opinion of that candidate in a way that may have changed the result. You know, is that actionable? Are we trying to reach the same harm as a deep fake? And so we want to make sure that we're not providing more protections concerning the use of deep fakes when you're trying to mislead or create falsehoods seeking a campaign result or an election result. And that's why it gets too big, and that's why the First Amendment comes in, right? Because I think as we've all experienced, or at least some of us have experienced, falsehoods are allowed.
Yeah, they certainly are, Senator, and that's a great concern to lay out. We have a tremendous amount of protection under that part of statute that allows effectively lying in campaigns at this point, and we would be providing a unique protection where you can lie most ways, but if you lie through deep fake, that would be a problem. You know, we see the concept of the cheap fake, which might fall into our synthetic media, but it's popular right now, where you don't take anything sophisticated, you just take an existing video and then you just frame manipulate the speed or something along those lines. That's the cheap fake concept. And so it can be very effective, very misleading, and certainly doesn't take any artificial intelligence to make something look bad. Interesting. But, you know, as we're looking to the next meeting, though, I think it might be worth pursuing a couple of different paths. One can be, you know, figuring out what we can do to fix Senate File 51. One can be creating another version of Senate File 51 that is very much an election-oriented, campaign-related Senate File 51. So we just take Senate File 51 and put it in the election statutes and then conform it and figure out how to make that work. That might be a good approach. All right, other thoughts going around the committee? Representative Andrew, so you mentioned that you have concerns about this bill and you don't like this bill. So what gets you to a yes on a bill similar to what we're discussing?
Mr. Chairman, I think that the entire concept, in my mind, is essentially just going to end up being a violation of the public's First Amendment rights. I think that, you know, free speech is potentially dangerous, but it's something that we tolerate regardless, and there are risks that we have to accept there. And this is probably just one of those things that I think we have to accept, and people are going to have to slowly learn to be more skeptical of the information they're finding online. I'm not sure it's the state's job to get involved in that process.
Representative, what about things like defamation, libel, and slander, and many other areas where we have limitations on free speech, again, in the public interest? and getting to my co-chairman's discussion earlier about the fact that you have free speech, but people don't necessarily have the ability to, without limits, eliminate someone else's free speech or affect someone else's speech, so to speak. It's that idea of rights coming into conflict, and how do we grapple with that? And maybe you're opposed to slander laws, libel laws, and defamation policy, which if you are, that's fair, and I'll probably withdraw my question.
Thank you, Mr. Chairman. I think the difference is that allows a person who has been harmed individually and specifically by speech to seek a remedy, and that is in the civil realm. I mean, once we're putting this in the state's hands, that to me is where I see us getting into a First Amendment violation. But
Well, again, we can take out we take out the criminal part and make it civil. And you can still have injunctive relief through the civil process. I don't think anyone's averse to that.
And Mr. Chairman, why don't we take the route of codifying torts such as false light and saying that they can be used specifically for these purposes? I mean, we've codified certain torts, but not all of them that could be used as a remedy for this. And perhaps that would make them a little bit more accessible. But, you know, if I may, going back to your
Yeah,
previous
go ahead,
question as well, I think that, you know, I think a lot of this has been centered around, are we essentially taking someone's right to free speech when someone makes a deep fake of them? And I think actually not. I mean, I think that forcing someone to speak would be, you know, threatening them, something like that. You know, you're somehow threatening somebody and forcing them, coercing them to say something, and that would be certainly a violation of someone's free speech. But this is somewhat of a modern art form, that it really is somebody else saying something. And, you know, they're using someone's image to do it. And that does seem very extreme, but I still think it lies within the protections of the First Amendment.
Okay. Thank you. Any thoughts or responses to that by anyone? All right, Representative Singh, same question. What are your thoughts on direction that would either make Senate File 51 better, or going to Senator Ellis's suggestion of taking this draft and narrowing it to an election bill?
Thank you, Mr. Chairman. After reflecting on some of the comments that were made earlier, political speech can't be compromised on. Historically speaking, the founding fathers that we appreciate the most, that we would look to for moral clarity in this type of situation, also engaged in misinformation campaigns in their political campaigns. And how that affected the public perspective of their ability to lead. Well, we can't ask them that. Whether or not we pass this bill, it won't make it won't mean that just because one of us says something on the campaign trail that we're actually going to live up to it. So that doesn't mean that we're going to be any more honest in that regard. After reflecting on the importance of political speech, I think I'm much more hesitant to approach the idea at all.
Thank you, Representative Singh. Mr. Co-Chairman?
Thank you, Mr.
And we can
Co-Chairman.
go online, maybe
Or-
hit our online
yeah,
folks first
sure,
and
go
come
ahead,
back,
Mr.
because we
Co-Chairman.
haven't heard from Representative Yin for his interest. Representative Yin, you're out there. I think we still have Representative or Senator Furphy, hopefully. So Representative Yin, Mr. Leader.
Mr. Chairman, I think as I've probably stated a couple of meetings before, I'm not super excited about bringing something broad. I would be more supportive of something more narrow. in the election realm. But I think we'd have to get language drafted to really see what that looks like. So bring a draft for next session that's targeted towards elections. I'd be willing to look at. But Senate File 51 as written, I probably would not vote in favor of.
Thank you, Representative Yen. Is Senator Furphy on still? Okay, I know he was going to run to something in a few minutes. Senator Furphy, if you're out there. I know he had to step away for a minute, so he'll probably be back. Anyone else on the committee want to weigh in? Mr. Pope, I know is on, and I don't know if Mr. Kaufman's on right now. Mr. Pope.
Thank you, Mr. Chairman. I've listened this whole time, and I still get back to let's look at the example of me as a professional. I have very strict standards for ethics, and if somebody were to create a deep fake of me doing or saying something unethical, like saying that I had examined Enron's books and they are solid and will continue for decades, that's one of the issues that I see in not having this, because I get Representative Andrews' statements about free speech, but I fall on the side of Co-Chairman Western and his statement that, you know, nobody has a right to my free speech. And so let's look at some of the consequences if someone did that to me. Every financial statement that I have given any sort of opinion on or helped prepare would then be suspect. What are my causes of action in that, and how difficult is it to achieve the bar or reach the bar that would be set for me to recover my my reputation in that. With this law, what are the how do those barriers change? They obviously go down. They're obviously lowered, and there's a much smaller, because there's presumptive harm in many cases in this, and I think that's because regardless of whether I can quantify the harm done to me, there is harm, and that's what this addresses. But even more than that, it is really nebulous as to what harm my clients would suffer. Their financial statements would suffer, and as it goes down the line, and this gives a cause of action even to them. And that is a situation where I really like the results of this, and I don't believe it harms someone's free speech if they are prevented, or if there are consequences for them to capture my free speech and manipulate it in the guise of their own free speech. So I understand free speech. I am someone that I've watched the political debate nationally on free speech through the platforms and all of that very closely, because and I believe that if I am saying something, I have a right to say it, even if someone else doesn't agree with that. But that someone else cannot and should not be able to manipulate my voice, my name, image, and likeness, to use the current term for it, in order to further their own ends, which could be, and in many cases would be, used to defame me or to create harm for me, or to promote, in many cases, using the example that I used, their financial statements by improperly putting my backing to it. So I stand in favor of the bill mostly as written. The criminal element could be taken away, I think, as long as it still provides me an easier cause of action using the kind of the presumptive harm theory in it. So that's my thought on it, and I appreciate your time, Mr. Chairman.
Yeah, thank you. Thank you, Mr. Pope. Appreciate it. Any questions for Mr. Pope? Yeah, go ahead, Senator Ellis.
Mr. Chairman, I think, again, we're starting to blend the legal theories. Like, we tend to gravitate, and we have today, on the campaign side of things. But what Mr. Pope just described is defamation as it exists right now. People can have an opinion and say John Smith is the worst accountant ever, which is an opinion, and people can say that, and you might not like it if you're John Smith, but a person can have that opinion. Comparing that to, John Smith broke the law. John Smith has these awful diseases. If you go to his business, you're going to get those awful diseases. And so in the normal world, that person then has to say, well, this is how these defamatory actions are affecting my business. And I can show you, I've lost clients. I used to have this many, and now I have this many. And those are all brought on the private person to take that claim to court and, tell it to a judge, like, here's how I'm being harmed by this. The interests that are at stake there are so different than I think they are in campaigns, because the state generally has a lot more rules about dissemination of information, what broadcasters can and can't do. They're just different animals. So that's where this bill fails for me, is it mixes both of those, because it's in this one title, and we're mixing theories of law that don't always mix. And for politicians, defamation, we're held to a lower standard. I mean, it's really hard for a politician to say, this is defaming me. Look, I didn't win this election because my opponent said XYZ. That's really a difficult thing to prove. So I understand what he's saying, but I think, again, if we wanted to pursue protections for what Mr. Pope's describing, it's just a different animal and should be in a different part of the statute.
Well, Senator Ellis, I think what Mr. Pope's looking for, though, is what this bill does, and things may need to be done differently related to elections because of the delineation that you lay out. The key consideration here is the idea of the dissemination of it as opposed to the creation of it. So defamation, you need a specific harm, and you need somebody who did cause the harm, and that isn't going to be the individual that disseminates it or the entity that disseminates it. It's going to be the creator, probably in a defamation case. This is then trying to go one step further and get to the dissemination of that speech and find a vehicle to shut that down, where I think, getting back to Mr. Pope's point, you have somebody that creates a false image of Mr. Pope saying something that's inaccurate that leads to a loss of his business in private practice, and you don't have any idea who the creator of it is and never will. Defamation doesn't cover that. And that's what this is trying to get to.
Mr. Chairman.
Yeah.
But just more thoughts. I mean, the more I read this over, we just need to think about it all, because, when we talk about synthetic media, some of this exists already, like photoshopping. So for my campaign materials, or maybe a TikTok video, sorry to use a proper name, or a video I want to produce online. Maybe it makes my hair a little darker so I don't have to get it dyed. Maybe get rid of a few wrinkles without having to use Botox. Get rid of a few blemishes, maybe lose a few pounds, stretch out my image. That is deceptive. I'm trying to portray that I'm younger, that I'm healthier and more healthful looking than I am. It's deceptive, right? And so is that what we're getting after? I just think all of these things need to be taken in their little silos as we consider them. So I don't know, just keep reading this over and over again. I'm glad we're going to continue to work on it.
Thank you, Senator Ellis. Mr. Pope, did you put your hand back up, or do you want to provide some more thoughts?
I just one other. Then this bill also takes it one step further to the viewers or the users of the information that's being disseminated, and what their harm may be. I don't believe that if, let's put it this way, if my clients had a cause of action under the defamation statutes or theories, and it would be even more difficult to prove than it would be for me. And again, it's this presumptive harm or presumption of harm that we're looking at. It may not be clearly stated within the bill, but that's really what we're talking about is the presumption of harm, and that's the part that I believe makes this very powerful and very useful for someone in my position or many other positions and not only them, but as the information and as the harm radiates out to the users of that information, it gives them power as well that they did not have before. I think that would be a wonderful thing to be able to achieve. And thank you, Mr. Chairman, for giving me the floor for a moment.
Absolutely. Thank you, Mr. Pope. Was Mr. Kaufman on right now or available? Okay. Okay. Let's get Mr. Revel if he's available and would like to weigh in. There he is.
Thank you, Mr. Chair. It's been a fascinating conversation. I do not believe that I have the depth to add here to First Amendment issues or existing legislation and what that would cover. So I'm going to pass, but am very much enjoying this and hope that the conversation continues.
Great. Thank you, Mr. Revel. All right. Representative Singh, so on the, I don't think you specifically addressed the circumstance where the criminal provision of this bill was removed and it was left specific to elections, but it sounds like you'd have concerns with that. Okay. Mr. Co-Chairman, go ahead.
Thank you, Mr. Co-Chairman. I think it was pointed out that we are singling out this specific type of political expression. And to me, I think, that's the exact point, right? For generations, for centuries, political satire, political commentary, et cetera, that's been around, completely nothing new. But I think it is in the advent of this new technology that we've never seen before is why we're having this discussion in the first place, outside the bounds of common law and all these other traditional venues when we deal with this concept of what is truth. And so I think there's multiple approaches. I would favor just us going with this bill, stripping it down strictly to the political aspect, the candidacy component of it. Of course, I'm not wedded to that specific option going forward, but I think at least at a minimum, that's my preference. But at the end of the day, the will of the body, the will of the body rules.
Thank you, Mr. Co-Chairman. I wanted to ask Representative Andrew, you mentioned a few minutes ago that nobody can force you to say something and that nobody should be able to force you to say something, which was a point you were making with regard to the forced disclaimer as a protected speech aspect. When you think about the idea now of somebody using your likeness to provide speech that you vehemently disagree with, how is that not a more egregious version of forced speech on your behalf? So you're a policymaker. We now have on one of our social media platforms a video of you giving a speech, for example, saying, I'm Representative Andrew and I'm here to come take all your guns or whatever the case may be, right? I'm confident you wouldn't say that, but we can certainly make something that is of you saying that. How is that not more of a concern?
Thank you, Mr. Chairman. I guess the difference is that I actually didn't say that. And I think that in that case, we're again looking at me being the one who was harmed in the situation by someone else's conduct. And for that, I have common law remedies.
What would your remedy be if you had no idea who created that content? Walk me through the remedy. So we'll say it's on social media platform. It's already got 100,000 likes. You wake up one morning. Walk me through your remedy.
Mr. Chairman, I'm not sure who I would be able to go after at that point. I don't know how this even helps that much if we don't know who did it. That's probably going to be one of the larger issues with this entire concept, is that if we don't know who, then it could be from a foreign country. And I think it's, if the platform it is being broadcast on is an open platform, it's a little bit hard to go after the distributors of the information as well, because they may not have known what was happening, or even the people who posted it may not have known.
Well, I think that's exactly the point, though. You have a circumstance where you have a foreign entity. You're protecting the free speech of the foreign entity by saying that they have a right to create a false image. You have a platform that is propagating it with no change of statute. You really just have to watch the theater as it moves forward and shake your fist and say, no, I didn't, and maybe post a little response. With legislation like 51, or if we revised it and had another act, or even maybe some of the bills around the country, you would have the opportunity to get an injunction and say, this is a deep fake that is being disseminated. And I'm asking for an injunction under this act. And if they were to continue to propagate it after that, then they would have liability for disseminating the deep fake. And there's little chance that they would continue to disseminate it at that point, because there's relatively significant potential financial harms to them at that point. So you would have an immediate injunction capacity in that circumstance if this bill were in place. Or alternatively, that platform would have to write at the bottom of it, this is a deep fake, or this is suspected of being a deep fake. So again, where would your remedy be now relative to what you might see with something similar to this bill in effect? And how would your rights, your First Amendment rights, not be the central issue of that scenario?
Mr. Chairman, I'm not sure what somebody else making something like this would have to do with my First Amendment rights. It doesn't limit me from saying anything. And in the end, I never said whatever was in this deepfake. So, I think most mainstream platforms are already taking these sort of precautions on their own. Certainly not everything, but I think that it's probably in the end going to be unenforceable, because I think you will find that it will be probably ruled unconstitutional if there isn't a parody satire provision. And as you've brought up many times, I mean, that's a loophole you could drive a truck through. And so you kind of have, you have a real issue there that it probably has to be one way to work. And if it's that way, it doesn't work.
Well, Representative, we could certainly try and craft a working parody and satire provision. I don't know that it's impossible. In fact, I think we probably should try based on the feedback. I just see that challenge, but if that were in place, would that provide you with more comfort? Maybe not get you there, but it sounds like that's something that you find important as well.
Yes, Mr. Chairman. I mean, I definitely find that important. That probably doesn't get me to being a big supporter of this concept, but certainly important.
Great. Thank you, Representative. Representative Singh, anything else to add at this time?
Thank you, Mr. Chairman. to me, it feels as if we're making a carve out for not a carve out, but we're telling everyone that they're not allowed to lie about politicians, but then the politicians are able to say something to their face and not necessarily follow through on that. So I'm having trouble with this bill right now.
I think the difference there is that it's your speech lying as opposed to somebody else's speech on your behalf lying. Mr. Co-Chairman, thoughts?
Well, and Mr. Co-Chair, to piggyback on that, what this current draft is saying is not that you can't say that, but if you do, you just simply have to just put a watermark on saying this is AI. You can create the most authentic looking, convincing AI video of me or anybody saying anything, that you just have to have a little thing saying this is AI created. So you can still say it, you can still claim it as parody or not. There just has to be the safeguards in place. So
Anything else? All good? Go ahead. Yeah, Representative Singh, sorry.
Sorry. Thank you, Mr. Chairman. I am also thinking of the particular circumstance in which someone downloaded a AI generation program on their computer or whatever the device they're using, and they, in their own personal capacity, decided to make a deep fake of you or me just for funsies on their computer. And then without their knowledge, someone got a hold of that file and then disseminated that. Would that then hold that person, the original creator, liable for any of the damages that we're talking about, even though it was never meant to be disseminated?
So the short answer is no. The Senate File 51 as drafted would not hold that creator responsible. And it goes to a great length to make it clear that you have to be intentionally and knowingly disseminating it with the intent to mislead. So yeah, that person's right off the hook as drafted.
Thank you, Mr. Chairman.
Yeah. All right. Well, before we take our afternoon break for a few minutes, let's figure out what direction we want to do. Mr. Chairman, I think there's a lot of interest in at least continuing the discussion. We certainly don't have a solution to vote on, but I think my inclination for the next meeting, and we'll see if anyone has any objection to this, would be to both fix Senate File 51 with some of the suggestions, and we can go through those, and create a parallel bill of an elections only version of Senate File 51, which would go in election statute pursuant to what Senator Ellis was talking about, with some of the fixes that we're talking about. We could talk about that, and then just bring those two back and have more discussion. And again, I don't think that's we've got one new bill draft, so that's some work, but at least most of the language will be identical. So I don't think that's hopefully Herculean. And then some tweaks to 51 as a new version that we could contemplate as a bill drafted for our consideration. So we can take those two, vote them up or vote them down. I don't think Senate File 51 probably passes the committee at this point in time, Mr. Co-Chairman, but I do think we should have it out there for more discussion and get more feedback on it. And maybe the narrower elections one ends up with support of the committee, maybe not. And I think, we can have more conversations and try and see what everybody thinks. That would be my inclination. If that's a good direction for us to talk through, then maybe we can go over some of the ideas on how to change this. Is everyone okay with that general direction? Again, not passing a bill, but talking about it more next time.
yeah, Mr. Co-Chairman,
ahead.
I think it makes sense, right? Giving us multiple options, whether it's a stripped down version of 51 or something new that's in Title 22. I think, because obviously our next meeting will be our last scheduled meeting.
Right.
So whatever we do, that's going to be kind of the final action on the issue. Yeah, I think that makes sense. I mean, unless there's any objections from LSO, doesn't look like it.
Does that work
David's reaching for his mic.
conceptually? And we can go through the details of what
Uh,
changes.
Yeah, Mr. Chairman, I think that there shouldn't be any trouble drafting two different bills. I would be interested in clear directions on what you want
Yeah.
changed.
Well, let's walk through as a template. Let's walk through and just see if anybody has any ideas and changes they want on the SF 51 draft a little bit. and recognize that those changes will probably, well, you can note whether those changes would apply to both bills or just this bill, but there's a few things that we've heard suggestions of. The first change that I guess I'd just throw out there would be a removal of the criminal penalty in SF 51. So that's the G paragraph on page 5, just removing the G paragraph about a criminal penalty provision that seems popular. So it becomes civil only.
Mr. Chairman?
Yeah.
Would a conforming amendment then also remove the Attorney General investigating violations since it's civil? In paragraph, let's see,
I feel
B
like,
and then E.
how does consumer protection end up happening? Doesn't that happen through the AG's office sometimes, where investigations for consumer protection are done through the AG's office?
Mr. Chairman, I think this gets to the whole heart of the problem, though. So we could talk about the defamation, which is you and me, you're the
Right.
worst professor I've ever seen.
Hey.
Disagreement, right? Which is between you and me.
Right.
The AG is not going to
Right.
figure that out. Or are we talking about a consumer protection bill, and this is about an advertising, there's no disclaimer. That's a separate concept. If we're talking about advertising, that makes sense. But if we're just talking about defamation between two parties, then that doesn't seem to make sense to me.
I think they, in theory, and again, we can talk this through, but in theory, I would say that choice would be made as to whether the Attorney General wants to represent a class of Wyoming citizens that they believe have been misled. They would have the capacity to do it, as would a district attorney on behalf of the people, or individual people would have their own individual standing to bring a private right of action, which was kind of the intent originally in the discussion, was to make sure that the state could do it or any individual could do it. There's a lot of desire by industry to have it only be the state because they never want a private right of action because it's the thing they hate the most, is the potential for a lawsuit. But that was kind of the theory there. All right, so remove paragraph G. I would also suggest that we weave satire and parody into paragraph J. In some way. Anything else on the 51 draft as we're looking at carrying it forward? Otherwise, I think those were the provisions we commonly heard.
I think so.
Okay. So now getting to a discussion of,
I think Daz has got it.
oh, sorry, Daza, sorry, missed your hand.
Thank you, Mr. Chairman. Just one thought, which is that there's a aspect of this relating to, public protection, but also the change in the way things are now with this technology basically messing around with the way that we've always thought of video and audio. In the past, even in rules of evidence in a court, but also in general society, when you kind of roll the video clip or play the audio, there's this kind of presumption that we now have evidence of something that probably happened. People defer to it. And one of the things I've been hearing that makes a lot of sense to me that may be appropriate for a legislative body, more so than others, is to in some way perhaps encourage through public education and public information campaigns the message that just because you see something on video and hear it in audio does no longer necessarily means it's authentic and genuine and true. It's like a new way of thinking, and up to now, people's parents and in schools and in other places, like we've come to learn, watching media, that video and audio is more likely true than not. It's kind of evidence. I don't think that's going to be so anymore. And somebody somehow needs to percolate that message out. And it's going to happen eventually after, a lot of tears are spilled and problems happen. But it may be a public benefit to get slightly ahead of that, either through your education system or other methods that the state has for public education and public information.
Good points. Thanks, Dazza. Any questions for Dazza on that? All right, seeing none, thank you. And we can give some thought to any way we might be able to integrate educational aspects. I don't quite know how the government is seldom very good at public education campaigns. It's not one of our strengths. On to how to translate Senate File 51 into an election related bill. I think one of the things that we can and should change, in addition to the two suggestions, which we would probably, once again, I assume, change just as we discussed, take away the criminal provision specifically and add some satire and parody language. One thing that other statutes have is with the intent to change the election outcome as the intent of that manipulation. And I think we could put that as the specific language in maybe on the page 2B paragraph, a person engages in unlawful dissemination of misleading synthetic media, and we can call that something else related to elections. When they knowingly and intentionally disseminate synthetic media, knowing it to be synthetic media. And then we've got provisions for that. We would basically have with the intent to manipulate the outcome of an election as a key provision. And I think that is helpful. One other provision on probably both bills, which was suggested on page 3, talking about some details of how the audio comes. We could soften that language and strip out those last paragraphs in both bills because it is a little bit overly specific. Which disclosure shall be read in a clearly spoken manner and in a pitch that can be easily heard by the average listener. Ending it there so it doesn't have at the beginning of the audio, at the end of the audio, and if it's longer than 2 minutes. I think that was a reasonable suggestion of not being overly prescriptive on that language. So perhaps on both of them, remove that lines 10 through 13. Senator Ellis, anything else that we should be kind of including in a draft that goes over to the election side to make that clearer?
Mr. Chairman, I do think we need to think about the harm a little bit. So Senator Nethercott and or Member Pope talked about it, the presumption, just the concept of harm. And I'm just going to go back to, what if I just smooth out my skin and make myself look a little thinner in my campaign materials? Then I need to put a disclaimer on there that said this has been an altered image. I just want to be clear if that's what we're doing for campaigns. And if we keep that language in the other bill that applies more to advertising, I just think most magazines nowadays, wouldn't that have been helpful for all of us ladies who look at those magazines for years and years? Anyway, there's just a lot of things to think about. I don't know that I've got it all sorted out yet.
What can we do to address that aspect of it? I think at least saying with the intent to influence the outcome of an election.
Well, Mr. Chairman, wouldn't that be part of it? I'm trying to portray myself in a different light to my voters. I'm trying to influence how that election comes. And I would disagree with some of the comments that have kind of circulated. We have talked about, and this country does recognize there are limits on your First Amendment rights. It's not a complete free thing. But I think what Representative Western made an important point in political speech. I think how we've dealt with that is the disclaimers. You can say a lot, but you have to just say this advertisement was paid for by. That's been somewhat of the check and solution on that.
Right. Senator Furphy, we see you. Were you jumping on to provide testimony? video. Okay. So as we look to the election draft, Representative Andrew, do you have anything that we haven't already talked about that you'd want added to it? To see? No. Representative Singh, I know you're not happy with it, but anything that you'd feel better about?
Thank you, Mr. Chairman. I would like to chew on this idea for a little bit, so
Sure.
let's move it forward.
Okay. Anyone else online? Representative Yin, did you have anything that you would like added to either of the two drafts for next time?
Nothing at this time, Mr. Chairman. Thank you.
All right, great. Do we see anyone else online with their hand up? Okay. Any objection to proceeding in this path? Those two drafts to look at next time? Seeing no objection, without objection, we'll move 51 forward with the amendments suggested into a draft for our consideration at the next meeting, and then prepare a parallel draft that is specific to election-related misleading synthetic media. Okay, and with that, let's take 15 minutes and be back at 4:10 for our final discussion related to additional AI topics. All right, we're back for the last discussion of the day. And today we're looking at some other discussions under artificial intelligence and contemplating some of the concepts that we have heard about under consideration in other states related to artificial intelligence. And this is just a general discussion and an opportunity for public comment and to weigh in on these topics. The topics that we've been looking at, Mr. Co-Chairman, include regulating AI liability, data provenance, we had a bit of discussion on, and automated decision-making issues related to artificial intelligence. And this is an opportunity to maybe hear a little bit more about that, discuss it as a committee, and then contemplate whether we want to have any legislation drafted at this time or to continue learning about those topics as we move forward. I know that Mr. Greenwood was going to provide us with some testimony and weigh in on these and potentially other artificial intelligence topics. So I think if he's available, we can start with that discussion and then look for other public comment and go to the committee for discussion. So Daza, welcome. We appreciate once again having you here. If you'd reintroduce yourself, that would be appreciated. But again, you know, we welcome the opportunity to hear from you on what you're hearing from your colleagues in studying emergent artificial intelligence policy and regulatory issues, and particularly again with regard to liability provenance and automated decision making, if you're hearing anything that we should be contemplating. So with that, the floor is yours.
Thank you, Mr. Chairman, members of the committee. I am Daza Greenwood, and I am Executive Director for the MIT's Computational Law Research Group. That's law.mit.edu, and I run civics.com. That is a consultancy that works in the area of legal engineering, or basically creating technology systems that conduct legal tasks and processes. And so, as you can imagine, generative AI in the questions of liability and automated decision making comes up a lot. And I would be happy to share some observations about how it's coming up and some thoughts for areas that could be ripe for state legislation. So the first thing I'll say is I think the area that's most ripe among the three topics that you mentioned, with automated decision-making, provenance of data, and liability for AI systems, is actually the automated decision-making technology. There's a number of statutes and regulations that have already started to address that. So I'm going to focus more on that, but I do think that it's closely related to the liability question. With provenance is sort of another topic, so I'd like to just separate that out. The first thing is just defining automated decision-making systems. And broadly, it's when you've got some machine system that uses data and algorithms to make decisions. And then where it gets a little bit different is some approaches are where there's minimal human oversight and review, and others are where there's zero human review or approval. And they encompass a broad range of technologies, and they occur in really virtually every context in the economy and society at this point. Some of the harms that are discussed with systems like this, or in the policy context at least, are perpetuating bias, that has made its way in through the training data, for example, or the way the systems have been coded, eroding transparency about who decided what and when and why. And one that I would sort of add myself is just general over-reliance. I am a big proponent of leaning on these technologies to conduct transactions and other systems faster, cheaper, and better. And when it comes to generative AI, especially the top models, I think one of the biggest problems is that they're so darn good. They get many things right, and it looks very finished. And there's a temptation to just take the outputs of these models and put them forward as a finished work, like to third parties, to consumers, to citizens, to other businesses. And that can be a problem because the technology does have flaws and it does have limits. I testified a while ago now on the Dow LLC about the tragic example that's happening in the UK now with the post office and the over-reliance on a financial accounting system that was supposedly spotting fraud and the resulting prosecutions of local postmasters, several of whom went to jail. Many lives were ruined. One of them committed suicide. It was really tragic precisely because it was totally bogus. The system was flawed. And the post office and the Crown prosecution over-relied upon the system and did not listen to the pleas of innocence on behalf of the people that were prosecuted. And now it's become a big deal. There's been parliamentary hearings and, people's convictions have been overturned. And, there's tribunals to try to find accountability within the post office, which is tough in that bureaucracy. But the point is, it's very tempting to kind of have our own bias in favor of automated systems. And, this isn't new to generative AI, but I think it's going to be exacerbated by generative AI because it's in many ways better than the prior technologies. And so I think that's a real risk in this context. These automated decision systems come up a lot in banking and finance, and they have for a long time. Criminal justice, like sentencing guidelines, there's algorithms for that now. Advertising, like new ad tech, is fundamentally a huge automated decision-making algorithm that decides, what offers you'll get and broadly what opportunities you may have. Also, there's tracking issues. It's coming up, as I said, in every part of the economy. And the way jurisdictions are starting to handle this, I think, is instructive, but I also think it's incomplete. So I now live in California. I'm learning California law. There's a lot of it. And I think the California Consumer Privacy Act and the CPRA that had some amendments are probably the best example of granting consumer rights in automated decisions, including opt-out and explanations. And there's also some very complex regulations that are floating around now as part of a notice of proposed rulemaking with more definition on that. Colorado, Connecticut, and Virginia also provide consumers with opt-out rights for what they call profiling as part of these systems when there's a high impact decision. Texas grants opt-out rights, but only for fully automated processing. So the kind where there's no human review and approval that I'd mentioned. Delaware, Indiana, and Montana combine opt-out rights with data protection assessments for what they call high-risk automated decision-making technology systems. And at the federal level, there's the main thing is there's a proposed Algorithmic Accountability Act, which is making its way through the legislature. Nobody is betting on legislation at this point, but it's a good example, and it's going to come up again next session. And it would regulate automated decision-making across many sectors. FTC is also pursuing this. They've had hearings and floated some rules. So it's out there. And I think the themes are transparency, accountability, and consumer rights. But as I mentioned earlier, I think the current approach is incomplete in terms of how automated decision-making technologies emerging now because of generative AI. And what we're seeing now isn't just like big enterprise systems that are, performing, like welfare benefit determinations as part of like a big platform, but or banking systems doing loan origination decisions and that sort of thing. We're actually seeing a lot more interesting, smaller applications that are bespoke. And the term that is used for this is agent, automated agent or autonomous agent. And there is a huge number of startups now and larger companies that are providing products and services that are, like I would kind of say, the category I would call it is agentic AI systems. So they're fueled by this generative AI that can look at interesting novel circumstances and apply rules and do reasoning of some type and give you an output in a standard format. And it not only can make some of these existing transactional processes faster, better, cheaper, but it actually can do whole bunches of new things that we could never do in automated ways before. So it's starting to open up new business models and new markets. And the main thing is that the issues when you look at autonomous agents are a little bit different than when you're looking at like the kind of regulatory scope for automated decision-making technology. It's closer to what David Pope testified to not too long ago, when he's saying, what about the situation where there's some system and it's making determinations purportedly by me about financial statements. So I think he said like Enron's going to be solid for 10 years or something like that. That came up in the context of someone, kind of weaponizing the system against David, I think, because of the prior discussion on synthetic media. But the way this is coming up a lot now is people are choosing to use these systems to conduct transactions on their behalf, kind of paperwork and other stuff too. And it's coming up with outputs and decisions that may or may not, be in their best interests. And especially when there's third parties involved. So like in David's example, he's doing a filing to like a regulatory agency, presumably in that case. That's where this automated decision-making in an agentic process raises particular liability and public policy questions. And again, I'd say exactly in theme with my prior remarks, I think existing legal frameworks can carry us a really long distance in looking at this novel technology and some of these relatively new use cases. And in particular, I'm thinking about the Uniform Electronic Transactions Act, which, as the committee knows, Wyoming has. It actually has a section that's titled Electronic Agents, and it's defined in your law as a computer program or other automated means used independently to basically conduct transactions in whole or in part, quote, without review or action by an individual. So it's exactly what we're talking about. And part of what's great about just looking at this existing legal framework is it has provisions for attribution. So like, what legal party or parties are responsible for the actions of this automated system. And that's where you can start to get to allocating and attributing liability, things like that, and transparency. And it also has some great provisions for error prevention and correction. UEDA, one of the issues is there's a bug in the system or it did something that was unexpected. And then if you kind of find out later when you get the receipt or the thank you for your transaction, it provides you a period of time to go and correct that error. So UEDA is a great existing legal framework that can be applied to a number of the issues that arise with automated decision-making when it's being used more broadly through these AI systems. And in closing, just a few thoughts where there may be some gaps, I think, are one thing is, it's one thing to inform people that a decision has been made by a automated system, but I feel like for that to be usable by people or businesses, when these things are B2B, some sort of tracking number, that says like, this was the decision, would make it much easier to follow up and ask for more information, to perhaps ask for human review, something like that. So that's something where I think, in implementation, having a general statement buried in the terms and conditions or a general alert at the bottom of a page that automated decision-making is happening somehow is, probably going to fall a little short of achieving the intention of having some rules on this about attribution and allocating liability. And the other thing I sort of hinted at it, but in some cases, I think before people go to court, just being able to click a button or request human review for some high impact or high risk or, some existential kind of decision that was made by a machine might be a very nice interim step that could be appropriate for legislation. And finally, I'll just say that many of the people in the group of experts I'd assembled for the committee on the generative AI session, the sort of educational session a year or so ago, are also we're collaborating on a joint initiative between MIT and Stanford, looking specifically at agentic AI systems, because there's a ton of startups coming out of our schools that are doing this, and it's a big part of what's happening legally with generative AI now, and we want to get ahead of it a little. And I would just offer, if it would be of use to the committee, to assemble some of those same people that testified before and some other heavyweights that we have to provide maybe more considered and complete remarks on what these systems are and the benefits and the risks, and some potential ideas on on the application of existing legal frameworks or tweaks to those frameworks for the legislature to consider when you're dealing with the advent of automated decision-making systems. So that concludes my remarks. I want to thank you for your attention.
Thank you, Mr. Greenwood. That was excellent. Appreciate it. Mr. Co-Chairman, question?
Thank you, Mr. Co-Chairman. Daz, I really appreciate that testimony. It was very thought-provoking. And, when you kind of talked about UITA and some of those provisions, it kind of made me think about some of the language we have around fiduciaries, right? And how you're legally obligated. Do you think that there's, well, how applicable is that analogy, would you say, in this type of scenario? I'm sure it's limited to some extent, but what do you think?
Daza?
Thank you, Mr. Chairman. Mr. Co-Chairman, Representative Western, I think it's completely applicable. And in fact, I've been working lately with the Consumer Reports Innovation Lab and others, and they're extremely interested in the use of agentic AI by individuals and consumers to help them as they're interacting. So that's sort of their angle on it. And in the last kind of prototyping session we focused a lot, interestingly, not on code and protocols, but on law. And we looked particularly at the fiduciary duty of loyalty and the fiduciary duty of care. And for loyalty, what we were looking at was cases and kind of a law review articles that defined the duty of loyalty in a way that we could derive technical requirements and constraints from, so that we could see if we could start to build those types of behaviors into the agent systems that Consumer Reports is starting to prototype on behalf of the consumer in this case. And that really helped get us further to making sure that the system didn't produce anomalous, kind of surprising outputs when the consumer discovered what it did later. So this duty of loyalty is a great one from fiduciary duties. I think there's a lot of other fiduciary duties as well that could come up in various ways. The main thing, just if you kind of zoom out, other than that anecdote, is when people and businesses, especially small businesses and consumers, are dealing with agentic systems, it's seldom at this point in history their own system that's doing things on their behalf, although that's increasing. It's someone else's system that's doing things with them, or arguably to them in a way. And so that people may not be aware that the system that they're interacting with is not operating on their in their best interests. It's operating on behalf of a different principal, and principal, PAL, a different boss. And so you can kind of cure some of that with disclosure and things like that, but at some point making sure both parties have agents with capabilities to engage with each other is, I think, where this is going to end up. And the fiduciary duties, or the equivalent of them, will be owed by those agents back to the party that's deploying that agent, and then they'll sort of fight it out.
Follow up, Mr. Chairman?
Thank you, Mr. Co-Chairman. I do. And as I appreciate your kind of extrapolating that concept. The other thing you mentioned that I found kind of fascinating was, that tracking number for decisions. The same way we've gotten really good at tracking packages from Amazon. Conceptually, it's the same thing for AI and AI decision-making, where if it makes this decision, that decision has a tracking number, and it can be audited and go back and look through the logic, the principal logic that these algorithms used. How practical is that idea in terms of putting that into legislation of, if you're serving customers interstate, you have to be able to track or audit or have a tracking number for these decisions?
Daza?
Thank you, Mr. Chairman. Mr. Co-Chairman, Representative Western, I think it's fraught So I offer that as an initial thought of an area that could be useful. I think it would be incredibly useful to have such a thing. I think there's a million ways to go wrong and to prematurely regulate or over-regulate or, impractically regulate. And yet, I think as the committee, as the select committee matures its understanding and starts to look at drafts and things in this area, if you do, eventually I think that you'll come to look at distinguishing different kinds of decisions, and some of the high risk, high impact, mission critical, high value, very sensitive, that kind of category of stuff, may be appropriate for somewhat for a few more requirements. And I just having built a lot of systems and engineered them and then went with companies and governments when the systems go wrong and try to remediate them, I just know tracking numbers can be a really handy tool, but used sparingly in the right, like targeted though to exactly the right thing. And I believe it's premature to specify that at this time, but it may be a good tool, a good arrow in the quiver when the time comes.
Anything else, Mr. Chairman, at this time?
No, I know.
Okay. Des, I have one quick one. Well, first of all, let me go to the committee. Representatives, anything for Mr. Greenwood at this point? Do we see any hands from the committee online this time? Okay. Then, Mr. Greenwood, one maybe lower hanging fruit. We heard circumstances in the past of states using AI or algorithms, probably more likely algorithms than anything that's particularly advanced AI, for what would effectively be high stakes decisions. I think you mentioned one with regard to corrections. There's concern with that. And what have you seen any states that have tackled this head on with either having a set of requirements or a human in charge, a human review, something along those lines? Do you see any legislation out there or best practices that we might want to consider with regard to state decision making using algorithms or AI?
Mr. Chairman, I haven't done a review, to be honest. I've sort of anecdotally, some people send me things and I see things in, the news like everybody else. But I've not gone deep into the sentencing guidelines and the other corrections contexts. And so I'm afraid I don't know. However, it is on the deliverables list for that experts group I mentioned from MIT and Stanford. So I assume by your next hearing in September, we'll all know a lot more, at least in my group, on that topic. At a high level, I think two things, just kind of off the cuff. One of them is humans. I feel like for sentencing and depriving people of their liberty, a human really should be reviewing these things and be accountable to them prior to it just being rubber stamped in some way by a tribunal. And the other is that I would love to see a system where every defendant, no matter what their means were, had readily available, high quality algorithmic systems of their own that was tuned to the sentencing guidelines and to their circumstances, and it maybe had different merit order algorithms so that they could make the case to the same tribunal as to why they should have maybe a different sentencing outcome. But I think this technology is powerful. It's powerful for law and justice. And for our system to work, our adversarial system, both sides need access to the same technology. And then, the crucible of the adversarial system at the end will mete out justice, we hope.
AI battling AI, right?
I think that's where it's going. Yes, sir.
Yeah. So one of the other areas in addition to sentencing was provision of benefits, healthcare benefits, for example, or Medicaid, where eligibility levels were being decided by algorithm. And so decisions related to the availability of benefits to individuals were apparently automated. And again, you have a high stakes decision where there might not have been a human getting involved in the process. So you can imagine 1 month you are covered by Medicaid, and the next month you are suddenly not covered by Medicaid, and a computer has made that decision for you. That's another area of potential concern, getting back to what would a best practice for government be, and how would we potentially draft that, where you have a decision of that magnitude, how do we get a human involved? And the other aspect of it is, how do we get a human involved objectively, where they're not just saying, yeah, that looks good, I agree with the algorithm. Is that something that your groups are going to be talking about, maybe working through? Because I do think that's an area where we might want to get involved.
Thank you, Mr. Chairman. To the first one, yes, it's a group that it's an item that we're looking at. The second one, how do you make sure someone doesn't rubber stamp in effect or over rely on the outputs? That's not something that's in the scope of that group. It's something very much on my mind, and it's something that I think we need to take a much closer look at. In the context of benefits determinations, I'm speaking individually now, not like on behalf of some institution, and certainly not other members of that group I mentioned. But to me, I sense this is a very good candidate for applying a sort of customary due process of transparency. So when the government has a decision-making rubric of some kind, like maybe it's in statute, and then it's more defined in regulation, and then it's much more defined by the agencies that are deploying the systems, I think all that stuff should be 100% transparent to the point where the algorithms, at least the decisional part of the algorithms, are published as part of the rule. It shouldn't be, some public records request, and it should never be proprietary to the vendor. It's the application of the law itself, and people's rights and opportunities are at stake in this case, and it should be not beyond inspection. And so we should be able to see these algorithms at a minimum, and we should be able to run them on our own systems. And then one of the things that's great about that is if the law and the implementation of such laws were deployed that way, then people could have simulators. So they could sort of see like, oh, I've got like 2 kids and this is my situation. I made that much money last year. Would I be eligible for this or not? And they should get the same answer as the government would provide, assuming that this was truly transparent and we had sort of an open source reference implementation of it. I don't think the stuff should be hidden. It should be available and it should be replicable.
Good points. That that works for algorithmic, but does that really work for an AI conversation? And I guess this is something I haven't tried before, but if I ask the same question to GPT-4o 5 times, do I get the same conclusion each time, given the same input? I'm not certain of that. That's an interesting question. And will that always be the case? Do you have any insight into that, or is that something I should try right now?
Mr. Chairman, both. I strongly encourage you and all the members of the committee and everyone listening to try this stuff a lot and to get good at prompting and getting a feel for what the outputs are and the capabilities. It's just too good not to use as part of your jobs as legislatures and everything else. My own view on it is that that's what I was mentioning in my kind of prepared remarks, is that a lot of the existing rules with respect to algorithmic decision-making technologies assume a deterministic system. And that's what I was mentioning as well when I was talking about revealing the algorithm and letting it to be replicable. When you have these sort of non-deterministic systems, the generative AI systems, they by design can give you more than different answers every run. There's some configurations you can have with temperature and some other ways that you can kind of influence the consistency of the outputs, but they are prone to irregular outputs. And so that's a real consideration. I would not think that alone generative AI systems are up to the challenge to make a final public benefits determination. That seems like the wrong tool for the job. They can be good at doing certain types of analysis and decision support and so forth. So I think it's really not the right tool. And the only way to fully replicate that would be if the government was using an open source model, and then you could download the open source model from Hugging Face, kind of like install it the same way, ask it the same questions, and basically see if you get the same distribution of answers. And for that, you can use standard evals and benchmarks to kind of see if it's performing the same way. One of the reasons why we're bothering doing this initiative between MIT and Stanford again is because these are really interesting questions. I want to know the answer to these questions as well, and to know how far can we rely on and push this technology where it's useful and beneficial in the public sector and especially the private sector, and what are its limits and why, and where should we not use it, or where do we need additional safeguards? I think these are still largely greenfield open questions, and they require focus, especially as people just blithely go out and start using the technology for everything.
Good points, and I appreciate that. Any additional questions for Daza on this topic? Anyone that we have online with their hand up at this point? Okay, Mr. Co-Chairman, go ahead.
Thank you, Mr. Co-Chairman. So there's a kind of coming back full circle on this one. Out of the criteria that we talked about, data provenance, et cetera, that the decision-making, the human involved decision-making criteria is probably the most ripe for legislation. I mean, maybe we can try to bring that back into a little more focus of what that means in the here and now with this committee moving forward, given that we only have one more meeting in September. So with that in mind, I mean, what's the stuff that's front of mind for you in this area, in the human involved AI?
Daza, anything that you see that we should be looking at for a December meeting, or excuse me, September meeting, or should we just continue this conversation?
Yes, Mr. Chairman and Mr. Co-Chairman, there is, and I think a really simple, narrowly focused starting point that would still get Wyoming way ahead of everyone else is actually taking another look at the Wyoming implementation of the Uniform Electronic Transactions Act in combination with the Wyoming unique legislative treatment of individual digital identity and organizational digital identity. Because one way to look at the need for human review is to look at possibly leveraging those existing frameworks and the electronic agent frameworks and the decision frameworks for automated transactions, that sort of thing, and to consider naming the individual digital identity for individuals and the organizational digital identity for organizations as having a duty when there's a key decision that's being made involving a third party to have, literally just to say, to have human review. And there's some precedence for this in the committee with the amendment to the Dow LLC Act that indicated one of the grounds for dissolving a Dow LLC is when it no longer has a remaining human being. There has to be a human involved to conduct the business transactions of an LLC in Wyoming. That makes a lot of sense, and sort of a parallel incremental approach in this somewhat broader area could also make a lot of sense.
Mr. Co-Chairman, follow up.
Thank you, Mr. Co-Chairman. Maybe we can just, before we wrap, or tomorrow or today, or when we have committee directives, we can just kind of mold that one over.
Noodle on what that would look like.
Yeah.
Yeah. Daza, did you look at the statute specifically enough to have a sense of how that might be applied statutorily?
Mr.
I see the
Chairman,
concept a little bit, but
yes, Mr. Chairman, I did. I've got sort of a draft of basically a markup draft, not with final language, but I have done that, and I'd be happy to share it with the select committee and legislative council or whomever to consider it as one of the inputs.
great. I appreciate that. That sounds good. Select committee, any other questions for Daza? All right, Daza, thank you for that. And I think, you know, your offer to have a reconvening of those experts that we talked to last year and have an opportunity to kind of hear updates on what's being worked on would be welcome. And maybe we can have staff touch base with you and figure out how that might work and how much time would be needed on an agenda. And if we can get that for our September meeting for a time block and just hear those updates on what you've been discussing. So we keep this on the radar and keep talking about what the newest and most thoughtful ideas. are right now and what we should be looking at, I think we'd really appreciate that. Do you have any sense of, we're looking at that September timeline. I don't know what you'd think of availability or how much time it would take, but do you have any preliminary thoughts on what might be the type of presentation you could put together with us, with that group that you were discussing?
Yes, Mr. Chairman. So let's see, I got some notes on that right here. So I think it's basically time, I would think something like half an hour, given how much you have to do and it's the last session, would be appropriate. And the points that I had thought would be best are, first of all, just some basic education, going through a bunch of examples of the growing prevalence of this technology in the market and the public sector, like specific examples. And then two that I wanted to go into a little deeper, and where we have people behind them are, one is Devin, which is this amazing agent that will basically create working software programs and has 4 agents working in a team. And it's crazy. The other one is from one of the people that testified last session, John Ney, whose current startup is called Norm.ai, and he has a continuous regulatory compliance agent that he's selling, which does really interesting things. So anyway, just show you a bunch of examples of how this stuff's really playing out, and then some just to maybe kind of abstract out what are the benefits, and they are considerable, as well as what are some of the risks. I think it's the real story here is benefits. And then some ideas on how Wyoming could proactively address the technology, including encouraging its beneficial use and perhaps looking at some safeguards and protections. And the markup that I'd mentioned, we're just focused on safeguards and protections, but I think the major thinking is how Wyoming can leverage this technology to get ahead, because it's available and it's underutilized in the market right now.
Great, thank you, Dazza. That sounds like a good plan. Let's plan on putting that together then for the next meeting. If you start contemplating that, it sounds like you've already done some work on putting together a good group presentation for that. We'll look forward to more on that at the next meeting, and we'll find what time works best for you during the meeting and your colleagues. So thank you once again.
Thank you, Mr. Chairman, Mr. Co-Chairman, and members of the committee. It's as always been an honor to testify before you. Thanks.
Great, thank you. All right. Following that, do we have any other public comment on our informational session regarding AI liability, data provenance, and automated decision-making issues? See anybody present here? Seeing none. Anybody online? Seeing none. Great. Public comment is closed. Back to the committee. Mr. Co-Chairman, I think we're probably still at the point of talking about this and learning, but do you have any ideas on what directions we might want to go?
Yeah, Mr. Co-Chairman, I thought that was very helpful and very informative. Maybe it's just my impulse to want to have something on paper that we can, bring to our colleagues. It might be worthwhile we only have one meeting left, but maybe it would be worthwhile for us to have a working group where we convene.
Sure.
That we show up for. Because I think the UITA idea there might be some validity there. Maybe I don't know if I'm onto something or not, but that's out of all the conversation I got in terms of what we can turn into legislation, aside from continuing the conversation, that's kind of where I'm at per Daz's suggestion. What do you think, Mr. Co-Chairman?
I think it's worth taking a look at and seeing what that draft might look like. We could potentially try and put something together, look at Mr. Greenwood's draft language, see how that would translate into statute. If it ends up being something that we could bring back to the select committee, we could do that at the next meeting. If it looks like it's going to be more challenging, then maybe we just come back and report, talk it through, bring the draft and discuss how we might potentially move it forward at a later time, but I think it's worth taking that up and trying to get ahead of it if there's that possibility for the next meeting. So it's a good idea. Other thoughts? How does that path sound, trying to look at the combination of UITA and the digital identity and get some human in charge language, figure out how that might look for circumstances where you have to have a human engagement on a situation where you have an algorithmic decision? Go ahead, Representative Singh.
Thank you, Mr. Chairman. I hope that this serves as a conduit for a conversation about automated vehicles and the reality of that being a part of our industries.
So, Representative, we had, and we could potentially even bring it back, we had a really good bill on automated vehicles 3 years ago-ish.
Yeah.
Something like that,
3 or 4.
3 or 4 years ago. That we drafted, we worked through, we did a lot of working group meeting in the interim. And then we handed it to the Transportation Committee to take. And they amended the heck out of it, Christmas treated up, and then nobody supported it anymore.
Got burnt down.
And that Christmas tree burned down. So Wyoming still does not have a automated vehicle statute in place, and most other states do. If we wanted to bring that back and try and do it again, we've already got a very good bill draft. We could probably just bring that bill draft back and take a look at it again, see what the best practices are between now and our next meeting, and rework that. That's something that it fortunately isn't as heavy of a lift as it would be if we didn't already have the bill. But I think the bill would probably need to be modernized a little bit since it's been 3 or 4 years. So we'd have to look at what best practices are out there and potentially revise. But we worked the heck out of it. It was really a good bill. And Mr. Co-Chairman, I think we could be open to doing that. Representative Singh, sounds like you're interested in seeing that.
I may go.
Go ahead.
Mr. Chairman, you are correct about that.
Mr. Co-Chairman.
Mr. Co-Chairman, I think my thought is maybe give that bill a read through. And if that's in line with kind of what you're thinking, we can keep that conversation going. If not, then we can always go back to the drawing board. That would be my recommendation, Representative Singh.
Representative Singh?
Thank you, Mr. Chairman. I just bring it up because that is the type of decision making that we're talking about in a practical sense. So.
Well, I think that's a decision for the committee, whether we want to bring that for next time, because if so, we'll need a directive to get that drafted, redrafted, and then modernized a little bit, which would require a little bit of work and probably even revisiting with some of the stakeholders in the space to find out what the best practices are. Committee, what's your thought on that? Senator Ellis, do you remember that piece of legislation? I don't remember whether you were on yet or not.
No, Mr. Chairman, I wasn't on, but I just want to be mindful of our staff resources. Like, I think the interim always starts out as a giant funnel and we should be working this way. And so I get a little nervous when we start going that way. So
Fair.
staff, I just mindful of their time and all the other demands of the many committees that they're servicing.
That's a good point. And we can honestly dust it off and take a look at it and see where it is a little bit and even bring that as a private bill, because it is an important issue that never crossed the finish line. The following year, the Transportation Committee looked at it again, I think during the interim, and didn't end up bringing a bill to my recollection. I'm not certain of that. I don't remember seeing it in the Senate, certainly, so I don't know what happened to it. Mr. Co-Chairman, anything else in your eyes that we want to do? I think we can work the UITA.
Yeah, Mr. Co-Chairman, I think that's probably our best jumping point. I think if we do want to put anything concrete. So at this point, I think I did kind of like the data provenance discussion, but I think Daz did a pretty good job covering the decision-making component. So I think I'm good for now.
Okay. Select Committee, anyone else have anything that we want to see? It sounds like so far we'll have a look at the uniform, the UITA and digital identity for next time, and then have some time for presentations and updates, as we heard with the working group from MIT and Stanford on what they're looking at. Anything else that we want for artificial intelligence for next time? Any of our online folks want to weigh in? Representative Yin, Senator Furphy? Any hands up? Senator Nethercott, I think, is out there right now. All right, seeing none, that's how we'll proceed for artificial intelligence for next time. And with that, Mr. Chairman, we are at committee directives. Any other directives on any other topics at this point? Do you need anything from us that we've discussed today?
I think we're pretty clear on what's happened today, so I think we're
Yep,
good.
sounds good. Committee, anything else as we finish out the day? Seeing none, any hands online? All right. With that, then, we are recessed for the day, 4:58, Mr. Chairman. And we'll see everyone tomorrow at 8:30 when we'll call to order right here. And look forward to day 2 when you'll be chairing. All right.